Good morning, beautiful humans, and welcome to Defense Diaries. I am your host, Bob Mata, and this is our continuing coverage of the people of the state of Indiana versus Richard M. Allen. And I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
So there was a little action on the case today. Did you see anything? Is there anything going on?
There's some stuff going on.
Yeah, there's definitely some stuff going on. So this morning, we bright and early, we got copies of the motions. Well, there's several motions that were filed. One big one, a bunch of other interesting motions, and also a lot of exhibits that were attached. And how would you describe before we dive in?
I'd say that there is new evidence that are going to make a lot of people question whether or not they got the right guy.
Yeah, it's very, very interesting to say the least.
You know, before we get into the big stuff, because this is just going to fall by the wayside, and I want to mention it now because I was shocked by it. But one of the motions that they filed was dealing with correcting either the judgment or the sentence paperwork, whatever it was, where the judge indicated that the defendant has no mental health concerns. And I just think it speaks volumes to like her mentality on this case. It's shocking. She sat through the same trial the rest of us sat through and could write something like that. I mean, there was literal evidence presented to him of ongoing before, during, mental health issues.
I agree. I mean, I don't know if she's taking that approach because of the fact that they didn't bring it up outside of the context of his psychosis back, in 2023. I don't know if it was raised in the sense that he had continuing issues. I mean, we know that his competency was never challenged. So, and we know that they didn't put forth any kind of mental defect defense, which obviously, if your client is maintaining their innocence, you're not going to be bringing forth a mental defect defense. I mean, therein lies the rub kind of with that. You know what I'm saying? Because, I mean, they really would have had to have him admit guilt in order to bring a mental defect defense. So how do you work around that?
Well, maybe I need to re-bring up the motion, but I think it just deals with information about prisoners, like when they're for incarceration purposes. Like was that not the issue?
Well, I mean, I think it was, but I mean, it was certainly the issue as to the confessions.
No, I mean, in the motion that they filed today.
Well, we'll go through it.
No one's going to want to go through that once we go through all.
Everyone's going to want to go through all.
No, my point was just that she indicated that he had no mental health concerns, and clearly that's not the case.
Yeah, it was certainly disingenuous. All right. So, and we're gonna split these. There's a lot. So I don't want to get any guff from you, lady. You're gonna help me read.
There's only one that needs to be read, I think.
We're reading all of it. Quit
Okay.
being a stickler. You and your no real, like the people literally come here to have us read and explain. So we're gonna read and explain,
Explain.
and you'll enjoy every second of it, I'm sure. All right, so
will.
let's. I'll tell you what. I'll skip the appearance. How's that? Is that?
I would hope you would skip entering the entry of appearance.
I'm going to skip the entry of appearance. Well, I mean, it's relatively interesting
I
because
mean, you could just let them know that they entered a limited appearance because they obviously were no longer of record, Richard Allen's counsel. So his 3 lawyers entered a limited appearance for the purposes of filing post-trial motions, or what's referred to here as a motion to correct errors.
there you go. See, that was great.
But we don't need to read, like pull it up and read it to them. Like
Oh,
how
now I'm pulling it up and we're reading it. All right, just kidding. Okay, so I'm going to kind of go through them in the order they were attached.
Why don't we actually start with the pulling up the statute on the motion to correct errors?
Okay, why don't you? I'll pull the. Do you have that?
I'm about to, if I can think, because my brain's. I literally was trying to recall Alan's last name to pull up a research session that I already have for him. Oh my Lord, this is not good.
I mean, do you want me to read this thing while you're finding that?
Sure.
Okay. Done. All right. So the first thing that we've got that I'm going to pull up here is a motion to correct abstract of judgment. Okay.
That's what I was talking about. So.
All right. Okay. All of this, by the way, was filed 11th hour. The filing deadline was last night, 11:59 p.m.
What?
So, in typical fashion for almost every lawyer on the planet, especially defense attorneys,
definitely me.
Yeah, they used every minute of time that they had to
put together the best they could.
Yep. All right, so this is the motion to correct abstract of judgment. Defendant Richard M. Allen by counsel respectfully requests that this court issue an amended abstract of judgment. In support of this motion, defendant states the following. On December 23rd, 2024, this court issued an abstract of judgment in this case. Under Part 4 of the form, the court indicated that were, quote, no mental health concerns with the defendant. Paragraph 2, yet at trial, evidence was presented that defendant had significant mental health concerns throughout this case. Dr. Walla, Dr. Martin, and Dr. Westcott all testified about the defendant's mental health issues. Video evidence revealed behavior by the defendant while awaiting trial that raised concerns about his mental health as well. 3, providing accurate information on the abstract of judgment is critical to ensure the DOC is aware of the defendant's mental health issues so that the defendant will receive continuity of care and appropriate placement, effective treatment and medication, etc., etc., etc. So wherefore the defendant by counsel respectfully requests that this court issue an amended abstract of judgment reflecting the change in the answer under a quote mental health concern end quote from no to yes. Defendant additionally requested this court forward a copy of the amended abstract of the judgment to the Indiana Department of Corrections. I mean, this move is specifically made to get him out of Westville, because that's where all the problems arose. All right, did you find your statute?
Yep.
Okay. All right, I'll stop sharing and you share.
Yep.
Now, the reason that Allison is going to be going through this statute with you guys is because it is under this statute in which the motion of the most interest that we'll be going through this morning was filed pursuant to
So
this
it's
particular
Rule
rule.
59, a motion to correct errors. So it's not a prerequisite for appeal, which is unlike what Bob and I are used to, except when a party seeks to address one, newly discovered material evidence, including alleged jury misconduct, capable of production within 30 days of final judgment, which, with reasonable diligence, could not have been discovered and produced at trial, or a claim that a jury verdict is excessive or inadequate. All other issues and grounds for appeal appropriately preserved during trial may be initially addressed in the appellate brief. So it has to be done within 30 days. Any error raised, however, shall be stated in specific rather than general terms and shall be accompanied by a statement of facts upon and grounds upon which the error is based. The error claimed is not required to be stated under or in language of the bases for the motion allowed by this rule, by statute, or by other law. So, statement in opposition to the motion correct error. Following the filing of a motion to correct errors, a party who opposes it, and here that would be the state, may file a statement in opposition no later than 15 days after service of the motion. So the state has 15 days. In the statement of opposition, they may assert grounds which show that the final judgment or appealable final order should remain unchanged, or the statement in opposition may present grounds which show that a party filing the statement in opposition is entitled to other relief. Any modification or setting aside of a final judgment, I mean, that's not going to happen as an appealable or final judgment, which means the defense can appeal the denial. Cross errors. If a motion to correct errors is denied, the party who prevailed on that motion may, in the appellate brief and without having filed a statement in opposition to the motion to correct error in the trial court, defend against the motion to correct error on any ground and may first assert grounds for relief therein, including grounds falling within sections A1 and 2, which was just the newly discovered or inadequacies of the judgment. In addition, if a notice to appeal rather than a motion to correct error is filed by a party, the opposing party may raise any grounds as cross errors and also may raise any reasons to affirm the judgment directly in the brief. I think that we covered. Okay, so this part is important. Motion to correct error based on evidence outside of the record, which is what we have here because they are presenting new evidence. It's hard pressed to be considered newly discovered under the law, hence my enunciation on Section A, paragraph 1. Here comes my basement cough. When a
Basement cough.
when a motion to correct error is based upon evidence outside the record, the motion shall be supported by affidavit, which it is here, showing the truth of the grounds set out in the motion, and the affidavit shall be served with the motion. If a party opposes a motion to correct errors made under this subdivision, that party has 15 days to file after service of the moving party's affidavits and motion in which to file opposing affidavits. So that's going to happen here. It's not just that they have to respond, but they've got to file opposing affidavits. If a party opposes a motion to correct error made under this subdivision, that party has 15 days after service of the moving party's affidavit and motion in which to file its own motion to correct errors under this subdivision and in which to assert relevant matters which relate to the kind of relief sought by the party first moving to correct errors under this subdivision. I think that this rule
All right, so
is civil. So it's a civil,
there you go. All right, so Ausbrook says it's criminal rule 5.3.
oh,
You're
Lord.
doing so well in reading it that I just didn't
Oh,
want
Lord.
to
Strike all of that from the record. Ay, ay, ay. I mean, what I thought was that they're, like our civil rules apply to federal rules every so often, but yeah, this is not. All right, it's criminal rule what?
Michael says 5.3, I think. He says it's the wrong. He's like, it's wrong rule. 5.3, I think. I'm sending him an invite to see if he wants to come on.
That would be good because I already was about to say, shouldn't they have said this thing about the oh, wait. That's going to make things easier.
He says it's in the he says he references it in the motion to correct error. All right.
It's been referenced in the motion to correct error. I
imagine it's substantially similar.
5.3.
5.3. He nailed it. He nailed it. I had little doubt.
All right. So, I mean, it starts out the same.
Okay.
But it's much, much, much shorter. So.
Well, that's good. All right. Pull it up.
I was just going to read it because now that I've botched that, I mean, it's literally just that it states the same thing. A motion to correct errors is not a prerequisite to appeal except when a party seeks to address newly discovered material evidence, including alleged jury misconduct capable of production within 30 days after the sentencing date, with reasonable diligence, could not have been discovered and produced at trial. I repeat the enunciation on that point for newly discovered. All other issues and grounds for appeal appropriately preserved during trial may be initially addressed in the appellate brief. The time for filing was 30 days. And let's just see if this has any, if it has any additional rules. Okay, so maybe the state doesn't even have to file a response. So in Illinois, sometimes they will use the civil rules, like the civil rules will apply to criminal rules unless there's a separate criminal rule. Here, obviously, there is. So, my bad. But the issue here, as we'll see, is whether this is going to constitute newly discovered evidence that could not have been discovered and produced at trial.
Yeah, and that's
why
frankly,
didn't you take this down? Left that up.
That's one of the main reasons I want to get Ausbrook on to kind of talk us through that issue. Because that's going to be the issue. We can fully anticipate the state is going to have a pretty brief reply to this or response, and it's going to be of the nature that none of this is newly discovered. Oh, good. All right, perfect. Good morning. Michael, you're muted.
Yeah, hi.
Good morning, sir. So anything new and exciting going on today?
Hang on, I got to kill the YouTube video.
Oh, you have it running? Yeah, kill that. It's draining your...
I don't know that we can start asking him questions before we tell anybody what, like maybe we've got to read the first.
Yeah, and I'm willing to answer sort of like any procedural questions up front. It seems like I might, be more useful later after, the thing's been read and you've been able to, poke it. I know one person who was doing a read through on another channel was sort of slamming the defense because all they've got is a YouTube vid.
No, I don't see how they can say that.
That's what he was saying.
It's people that don't understand. But obviously there's I'm assuming, issues with this fitting into the newly discovered category. But I think Michael's right. It's so procedurally right now is not the time, for instance, where you would need to say something like the evidence was insufficient to support a guilty verdict.
No, I mean, you could. I mean, if you could try to take a shot at the trial judge first on that. I mean, that's what, right? I mean, it says a motion to correct error is not necessary to perfect an appeal. So, yeah, sufficiency you can always raise. Actually, you can raise sufficiency for the first time in post-conviction in
Wow.
Indiana.
Wow. That's
Well,
wild.
where there's well, think of it this way. It kind of makes sense because if the appellate lawyers didn't raise it, it's going to be automatic and effective assistance for not
Oh,
raising it.
right.
You might
Yeah.
as well say it's fundamental error. And by the way, Indiana courts will address insufficiency of the evidence on their own without an argument. They look at a case and there's like completely missing evidence on one element of the crime.
I mean, that's the way it should be. It shouldn't be a game of what did the lawyers say the right word at the right time.
Yeah. But I will talk a little bit about newly discovered evidence up front, so that maybe you have at least our framework to think about it in, and that is that the evidence. So you're going to get to two pieces of newly discovered evidence that the defense is claiming is newly discovered evidence, and our view is that it became newly discovered evidence because of the state's case.
Agreed. That was my position on it, that the surprise testimony and evidence that the state presented made evidence that was otherwise available that wasn't relevant before very relevant and highly material now, trying to slip it into newly discovered from that perspective. Does a Brady violation help here? And I guess I should wait, because all these questions without reading through it first are, so let's just stick with that newly discovered. Is that an argument that there's some support in the law as far as the state making the evidence newly discovered? I mean, you're not supposed to be having a trial by ambush and then the defense trying to figure out what exists in discovery and where to combat, undisclosed testimony and evidence.
Yeah, I don't have any particular case that's sort of similar to this. I mean, right. I mean, if you had this stuff at the tip of your fingertips at trial, you'd probably be like claiming that the prosecution opened the door, right?
Yes.
And then you'd be putting it in.
Yes.
That is if you had time, but we had they had a sequestered jury. They only had so many days.
Babe, why don't we read through it and ask Michael if he'll be generous to come back?
Or he can hang while we're doing it if he wants to poke his head in while we're reading it. So, Michael, and I asked
the only thing I want to say. Yeah, go ahead.
I was just gonna, and I had asked you this via text. So you penned this particular motion, correct, sir? Along with assistance.
I wrote a lot of it. I mean, I got to say that this was, a huge group effort. As I counted, there were at least a dozen and probably more like 14 or 15 people involved. And, it was, yeah, I mean, just a huge group effort.
Do you want to give some love to those that chipped in? Or do you want them to remain nameless?
Well, I gotta say, Matt Hoffman, Czar Kathy Shank, he came up with the video. As I said to him, maybe, if this ends up having legs, I'm gonna put out there, we'll see your Kathy Shank and raise you a Matt Hoffman.
Nice. If you guys don't know, Matt Hoffman is the primary private investigator for the defense. If you guys don't remember,
And,
from Baldwin, Antonio.
But you were going to say something, Michael.
Yeah, I was going to say, I mean, you know, newly discovered evidence is kind of a mushy thing too, because, for instance, when the science changes, so Christine Bunch was exonerated. She was convicted of killing her child in a house fire, in a trailer fire, I think it was. And arts and science changed, and she was exonerated by the change in the science. The change in the science was treated as newly discovered evidence.
But the problem here is your change in the science happened at trial.
Yeah, it did, and you know, we'll see. You know, we'll see what the courts say. At least there are facts in the record now for the appeal. If the motion to correct error doesn't go anywhere, you all know I've been a big fan of the chronic claim based on what happened at the safekeeping hearing, which is really unbelievable when you look at the list of what things that were wrong with that hearing. I mean, there wasn't a hearing; it was a proceeding, right?
Right.
You know, we'll see what happens. All you can do is put the stuff out there, make the best claims you got, and see what the courts do with it.
So do you think we should read without you and invite you back, or you want to hang?
You know, I'll hang in the chat. And
you'll come back if we need you?
Yeah, I can come back if you need me, or you know, maybe collect it.
Yeah, do it this way. Like,
up.
You've got the invite, so whenever you want to jump on, just jump on. You have free reign.
Okay, well, if somebody sees me.
Right.
No, I think I think maybe after people, you know, answering questions is probably going to be better after people have time to digest what's there.
Agreed.
All right, cool.
And I can rail on it without you being here, just in case I want to. Just kidding.
No, please, absolutely do. Look, I'm, you know, if I screwed up, I screwed up.
I don't. Well. I'm not saying that. I was just teasing.
I'm serious.
All right. Thanks, then.
See y'all later.
All right.
We'll see you in a bit. All right. So the first thing,
I don't want to critique it right while he's sitting right there.
What are you talking about? Like he no, Michael's good with it. Like he will always ask. He'll be like, "Hey, am I like out of my mind with this particular concept?" Like he'll ask me, and I'll be like, all right. He always says, "Ask your better half." So, okay. All right. I'm going to pull up. I'm not going right to it. There's a couple short ones that are interesting.
Oh, Lord. Okay.
Interesting. They're interesting.
I like to get right to the juice, guys.
All right. So I'm going to skip the motion for the hearing. This is the accompanying motion asking that there be a hearing regarding this motion.
You can summarize a couple of them, babe.
I just did. So that was the defendant's motion for hearing on a motion to correct error. Now this one I'm going to pull up because it's interesting. It is interesting. Okay. All right. So this is the motion to preserve specific evidence. Okay. So it comes now. Again, these were all filed last night, 11th hour. Comes now Richard Allen by and through counsel and moves this court order of the state of Indiana, including the prosecutor's office and all law enforcement agencies, labs, or state, federal, and local bureaucracies that possess any of the following evidence to preserve said evidence and not destroy or lose said evidence. Said request is made for the reason that said evidence may be used at any future trials should this case ever be retried, or may be used by future post-conviction lawyers in the event that the matter is not overturned by appeal.
So, and just to remind everybody, they filed a similar motion earlier and the court said it wasn't specific enough. And so we had anticipated that they weren't going to just let it go. They'd refile something. So this is what they're asking be preserved.
Richard Allen's attorneys request the following specific evidence to be preserved. All physical evidence taken from the crime scene or near the crime scene, including any belts, cigarette butts, or any electronic items, whether or not they were working. Hint, hint, the phone, all DNA swabs taken during the investigation or even during trial or afterwards. All forensic evidence obtained during the investigation or even during trial or afterwards. And in all reports or lists that identify anyone whose interviews were erased while in possession of law enforcement or the state of Indiana. All evidence identified on the state of Indiana's exhibit list or that may be exculpatory in nature. The items identified in 1 through 5 are not intended as an exhaustive list of items that the defense is requesting this court to be preserved, but rather are a few of the specific items that the defense is requesting following this court's previous denial of the defense's request to preserve evidence for lacking specificity. The state of Indiana has a continuing obligation to preserve any evidence that may be exculpatory in nature. So wherefore, Richard Allen requested the court to order the state of Indiana to preserve the evidence as detailed herein. Okay. All right. And this is the big guy. The big guy. All right. So this was, again, filed at 11:07 Eastern Standard Time last night. And it is defendant Richard Allen's verified motion to correct errors. Comes now the defendant Richard Allen by counsel and files his verified motion to correct errors for the reasons that follow. The court should either vacate Mr. Allen's convictions and or set the matter set out below for hearing. So the way that I'm going to do this, I've got all the exhibits pulled up, so I will contemporaneously pull them up. It would have probably been easier, frankly, if you had them all pulled up.
I was actually doing that. So I've got the first one pulled up.
Okay. So when we get to it,
I mean, some of them are in the body. So, but yeah.
Some of them are in the body. The links worked, right? You checked the links? Okay. Okay. Paragraph 1, in violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping, quote, proceeding of November 3rd, 2022. That, quote, proceeding was a critical stage. It was Mr. Allen was entitled to be represented by counsel, and under United States v. Chronic for 466 U.S. 648 in 1984 case and its progeny, the court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding.
So, and they're using proceeding instead of hearing because it wasn't a hearing under the law. There was, both sides weren't there. The judge didn't actually consider anything. I mean, they'll get into it obviously here now, but proceeding was chosen on purpose as opposed to hearing, which it should have been.
Yeah, it's heavy snark. The proceeding is heavy snark. Okay, so Indiana Code Section 35-33-11-1 governs safekeeping proceedings for pretrial detainees and provides in full. Read through it, babe.
Okay. I'm going to pull it up on my end. Okay, and provides in full.
Wait, where are your glasses? I like your hot for teacher look.
My Lord.
Oh, yeah.
So old. Upon the motion, 1, sheriff, 2, prosecuting attorney, 3, defendant or his counsel, 4, attorney general, or 5, court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death or represents a substantial threat to the safety of others. The court shall determine whether the inmate is in imminent danger of serious bodily injury or death or represents a substantial threat to the safety of others. If the court finds, got to make some decisions here. The court's not just rubber stamping it. If the court finds that the inmate is in danger of serious bodily injury or death or represents a substantial threat to safety of others, it shall order the sheriff to transfer the inmate to another county or to a facility of the Department of Corrections designated by the commissioner of the department as suitable for the confinement of that prisoner, and provided that space is available. For the purposes of this chapter, an inmate is not considered in danger of serious bodily injury or death due to an illness or other medical condition. Goes on to set forth Indiana Code 3533-11-2 that governs safekeeping proceedings for pretrial detainees, which provides the inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety.
Now, the issue here is that Richard Allen could not have asked for or requested the post-transfer hearing because he knew none of this was going on.
As the defense points out right here.
All right. So Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. Interesting.
That was surprising to me. I didn't know if that was already something everybody knew, but they're like hiding him in the jail under a pseudonym. I've never even heard of such a thing.
Well, I mean, the state's can argue that that was for his protection, that,
But-
you know, they didn't want other inmates to know. I mean, I'm
You know
how
how
I'm
they
going to
wouldn't
devil's
have known.
advocate what the state's going to argue in their reply. They're going to say, oh, well, you know, we were trying to keep him alive.
Well, when did they do their little press conference or press release, whatever, where they gave his name and said who they arrested?
I believe it was the 28th when
Right.
they
So
formally charged him.
why are they booking him under a pseudonym before anybody knows what his name means?
Let's call it anticipatory.
Mm. Mm.
So the next day, October 27th, 2022, Kathy Allen, Mr. Allen's wife, hired attorney Brett Gibson to represent Mr. Allen. Exhibit 1, affidavit of Kathy Allen. Can you pull it up, or I can pull it up?
I can, but I mean, it literally says exactly what's in
I'm
there.
pulling up. All right, I want to put this comment up by Regina Day or Rainy Day. Ali Mata, please always pull up the documents. Some of us process info visually, and when you read one thing with another thing on the screen, it doesn't compute.
All right. I'm sorry. I've got
Thanks,
it
Rainy
up.
Day.
Oh, you've
Rainy
got
Day had my back. I like it.
it.
All right, so this is the affidavit. I'm going to pull up all the exhibits, honey.
I have them, but if you want to
No,
do
I'm saying, like, in general, I'm going to pull them up so that people can see them. Okay, so defendants exhibit affidavit of Kathy Allen. The affiant, Kathy Allen, upon her oath under penalty for perjury, says, 1, I am Richard Allen's wife. 2, on October 26, 2022, my husband was interrogated, arrested, and jailed. 3, the next day, October 27, 2022, I paid Brett Gibson, a lawyer in Lafayette, Indiana, $5,000 to represent my husband. 4, Exhibit 1A is an email I received from Mr. Gibson's office acknowledging that I had paid Mr. Gibson to represent my husband. 5, the evening of October 27, 2022, Mr. Gibson sent a letter by email to the Carroll County Sheriff and Nicholas McClelland, the Carroll County prosecutor, telling them he was representing my husband and that they should cease all questioning of him. 6, Exhibit 1B is a copy of that letter sent to me by Mr. Gibson. 7, about 10 p.m., Mr. Gibson called me to say that he would not be able to get my husband out of jail because he was going to be charged with murder the next day. The affiant says nothing more. All right, so
I've got 1B if you want me to swap that
yeah,
out.
pull it up.
Okay.
I'll pull mine down.
Big enough?
I think it's a little too big, babe.
Oh,
It's like off screen a little bit. Perfect.
okay. Dear Administrator, please be advised that I've been retained to represent Richard M. Allen in certain matters relating to the investigation being conducted by your office. It is my understanding that my client is being detained by Carroll County Sheriff. He will not be giving any statements regarding this matter. If he is currently being questioned, the interview should be terminated. If you have any comments or questions, please do not hesitate to contact me. I can also be reached by email, and it lists the email signed Brett Gibson, and it is carbon copied to the Carroll County Sheriff and the Carroll, and specifically Nick McClelland at the County Prosecutor's Office.
So, I mean, the import of that is obviously that they knew he had a lawyer. Okay. So I think then you and I have some internal debate about how critical I think this is. I think that you're kind of the mindset it's not as critical, but I think when you look at it in the context of what ended up resulting because of it, that's what makes it critical.
The pleading makes the strongest argument that it can, and it makes a logically valid argument. I just, knowing how the courts can be and the law can be, they may very well just find that, who knows, that the connection, like the one is not connected enough to what follows, like the hearing itself. Like you're really complaining about the conditions. So whether he was there for the hearing or not, you know what I mean? But the argument is strong that it should have never been granted and he never should have been moved, and then so on and so forth. They make the strongest argument they can on this issue. It's going to be interesting to see if the courts consider it the same way.
Yeah, and I mean, to your point, I think you'd really have to show that there was some kind of motive in terms of law enforcement, specifically getting him put into Westville in particular, like that there was some kind of plan.
I don't know that you would for this argument, because the argument they're making is just is what they're about to make. So I don't even think that you necessarily would need to show that was their plan, as opposed to just show that it was a consequence of that action.
Okay, so what emerges from defendants exhibits 1C and 1D, which I'll share real quick. I've got them here.
But why don't you do me a favor? Just pull back up the petition.
Okay.
And then you remove it. You don't stop sharing. You just remove it. And then
well, I can switch in between. I can toggle between the.
All right, then go ahead. Do it that way.
Like for the only reason I didn't do that, I didn't seem to have the one that you just. I must have missed it when I was. All right, so. Okay, so Exhibit 1C. This is Rosie's affidavit. Okay, so the affiant Brad Rosie, upon his oath under penalty for perjury, says, I am a lawyer with a practice in Logansport, Indiana, and have been a lawyer in good standing in Indiana since I was admitted to the Indiana bar on June 7th of 2002. Since November of 2022, I've been an attorney for Richard Allen, who is the defendant under this cause number. Paragraph 3, in an attempt to learn whether Richard Allen's first attorney, Brett Gibson, had communicated with either Prosecutor Nick McClelland or then Sheriff Tobe Lazenby or any other law enforcement officer concerning the fact that he, Gibson, was representing Richard Allen effective October 26, 2022, I reached out to Brett Gibson via email asking him a series of questions. The purpose of my inquiry was to determine whether McClelland, Lazenby, or any other law enforcement officer was aware that beginning on October 26, 2022, Attorney Brett Gibson was representing Richard Allen after Richard Allen's arrest on October 26 of 2022. 5, Attorney Gibson responded to my email inquiry and indicated that indeed Richard Allen had retained Attorney Gibson following Richard Allen's October 26, 2022 arrest. A copy of said email, which is marked as Defendants Exhibit 1D, is incorporated into this affidavit. Furthermore, in his email response, Attorney Gibson stated that Attorney Gibson, communicated with Nick McClelland both by email and by cell phone and alerted McClelland that Gibson, was in fact Richard Allen's attorney. Furthermore, in his email response, Attorney Gibson stated that Prosecutor McClelland helped arrange a meeting between Attorney Gibson and Richard Allen at the Carroll County Sheriff's Office, and that said meeting did in fact take place between Richard Allen and Attorney Gibson, and that furthermore, Attorney Gibson advised Allen not to discuss his case over the phone. 8, I have attempted to gain Attorney Gibson's affidavit concerning the things that Gibson states in his email, but have been unable to do so at this time.
It should be sufficient because Kathy is identifying, it sounds like Kathy was copied on that email.
Right.
So she's saying it's an email she received. She received it from this person.
So the question I have from the legal perspective is, this all took place post arrest but pre-charging. So there was no case number. He hadn't entered his appearance. So
but he couldn't enter his appearance. It was like they kind of
that's my point. That's my point. That's my point, that there was no case under which he could enter his appearance. So like, for the purposes of them, when they charge him and they create a case number, at that point, do they have an obligation, since they know that Allen's represented, to make his counsel aware that he's been officially charged? What we know that Gibson finds out in short order, because of the problem, I think, is going to be that he ends up not filing his appearance the minute that he finds out that Allen has been arrested. So he's not counsel of record. So, and again, I'm devil's advocating here. Okay, so this is Defendants Exhibit D. This is the response from Gibson to Rosie. Hi, Brad. Wait, hold on. It's 4 pages. I got to get the view scrolling. Enable scrolling.
A little bit bigger. None of us can see it anyway.
Oh, sorry.
Oh, okay.
Hi, Brad. Attached is a letter I sent to the Carroll County Sheriff's Office and an email I sent to Nick McClelland on October 27, 2022. Regarding your questions, did you ever communicate in any way with the prosecutor or law enforcement officials before Richard's arrest? No. Did you ever communicate in any way with the prosecutor or any law enforcement officials after Richard's arrest? Yes. On October 27th, 2022, Kathy notified me that Richard had been arrested. We sent a letter to the Carroll County Sheriff notifying them of my representation. The sheriff confirmed receipt over the phone. However, the jail advised that Richard was not an inmate. I contacted Prosecutor Nick McClelland by email. He called me on my cell phone afterwards. He advised me that Richard Allen was in the Carroll County Jail and that they had him listed under a different name / alias. He arranged for me to meet with Richard at the jail that evening. Someone from the sheriff's office took me to a meeting room in the jail. It appeared that regular jail staff did not know Richard was there. Let me know if you have any questions, Brett. So then we scroll down. This is the email from Brett Gibson to
I'll
Nicholas
read that
McClelland.
while you look at your email. So this is, your text. This is from Brett Gibson to Nicholas McClelland. It's dated October 27th at 6:36 p.m. Nick, I have been retained to represent Richard Allen. His wife, Kathy, advised me that Richard was detained by the Carroll County Sheriff Office yesterday. She said he had not been released. However, I called the jail and they told me that he is not there. Do you know Richard's whereabouts? Is he in police custody? I want to confirm any interrogation is halted. Thank you in advance for any feedback.
Okay, what am I looking at? Which text? I didn't get a text from you. Are you talking about it in the group?
Yeah.
All it says is that to do what to do with what.
All right, you know what? Forget it. It wasn't for like an open discussion. It was for you to look
Oh.
at and figure out. So
Wait, are you talking about from Mata Inc.?
yeah,
I
God.
don't know what I'm supposed to be figuring out. It's figured out. I'm going through it.
No, we're talking about
Did you finish reading that?
yes.
Okay. Okay, so then there was another email from Ann Deedham sent the October 27 of 2022. Please find the attached correspondence. And that was the correspondence. It was that's proof that McClellan got it. So that he had notice. Okay. All right. So okay, what emerges from the defendant's exhibits 1C and D is the following, which we just went through. Sheriff Lazenby confirmed receipt of Mr. Gibson's letter by telephone the evening of October 27. Also on October 27, however, over the phone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McClellan by email, after which Mr. McClellan called Mr. Gibson on his cell phone. Mr. McClellan told Mr. Gibson that Mr. Allen was listed at the jail under a different name, alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail, where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to be Mr. Gibson. The regular jail staff did not know Mr. Allen was there. Still on the evening of October 27, Mr. Gibson met with Mr. Allen and advised him not to discuss this case over the telephone because calls would certainly be recorded. At about 10 p.m. on October 27, 2022, Mr. Gibson called Mrs. Allen to say that he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day, Exhibit 1. So on October 28th, 2022, without Mr. Gibson present, even though Mr. McClellan and Sheriff Lazenby both knew Mr. Allen was represented by Mr. Gibson, Mr. Allen was charged with 2 counts of murder, and Judge Diener held Mr. Allen's initial hearing. So shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. The letter and the envelope are part of the record in this case. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated that he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there and is shown filed in the court on November 9, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1, 2022, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognized by the United States Supreme Court in the Houston v. Lack case, a 1998 case, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. And that comes from Lawrence v. State. The safekeeping proceeding was plainly illegal from start to finish. First, Sheriff Lazenby transferred Mr. Allen to the White County Jail on October 28, 2022, with no safekeeping order in place. Next, Lazenby had no standing to make the safekeeping request on November 3rd of 2022 due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28th of 2022. Once Mr. Allen was in the White County Jail, the White County Sheriff was, quote, the sheriff statutorily authorized to make a safekeeping request under Indiana Code 35-33-11-1. Because
statute that we read earlier that's cited above that listed the 5 people that could make such a request?
Because Lazenby had no standing to make the safekeeping request, Judge Diener had no jurisdiction to consider it. And that's Schloss v. City of Indianapolis in 1990 case. Because Judge Diener had no jurisdiction to issue it, the safekeeping order was literally void. That's TDV State, 2023 case. A judgment is void if it grants rights or relief to a party that does not have standing to pursue the action. Pursue the action. All right, great cough.
So I will say, just from everything they've said, they very clearly have laid out that that proceeding was unconstitutional, that it was the judgment was void. All of those things have most assuredly been established with what they're saying. The question then becomes, does the court say all that follows thereafter is an extension of that unconstitutionality and illegality?
Second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lazenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lazenby, helping Sheriff Lazenby draft his safekeeping request in violation of Rule 3.10 of the Code of Judicial Conduct, the code. And that comes from
Naughty
the
judge.
Yeah, I remember sitting in for that hearing and was blown away. I'm like, wait, the judge helped him draft the request? And that comes from the June 15, 2023 safekeeping hearing. So Rule 3.10 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated Rule 2.9 of the code by engaging in substantive ex parte communications with Lazenby, which helping Lazenby draft the safekeeping orders certainly were. Having violated both Rules 3.10 and 2.9, Judge Diener was obligated under Rule 2.11 of the code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd, Bell v. State, and then Tyson v. State. See also Rule 2.11 of the code, comment 2, quote, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify it is filed, end quote.
Right,
Third,
the judge knows what he can and can't do and when he should be disqualified.
or he should. Third, Sheriff Lazenby's November 3rd, 2022, quote, request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There is no certificate of service attached. Indiana Code Section 353111-1 requires the safekeeping request be made by motion. Indiana Trial Rules 5A2 and 3 required that Lazenby's motion for safekeeping order be served on the parties. Because Lazenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for a safekeeping order, even if he claims Mr. Gibson was not representing Mr. Allen at the time. Sheriff Lazenby was required to then serve Mr. Allen personally. So there's your answer. So if he falls on the Gibson hadn't entered his appearance, therefore he wasn't the attorney of record, he was required to at least serve Allen himself.
And that's why they went through all that, rigmarole to establish that they knew he was the lawyer, both the sheriff and McClelland. Like, there's no question. The reason for filing your appearance is that everybody is on official notice. Well, they've established official notice. But
Definitely.
Right, they've got this backup, and if not, then they should have served Allen.
Right. So fourth, Lazenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by the Indiana Code that would authorize a safekeeping order. Fifth, because a factual finding was required to authorize a safekeeping order, a hearing with notice to the parties on Sheriff Lazenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the department. Lazenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer.
It's got to be given notice before you can refuse.
Right. So Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana Department of Corrections custody or to make any of the objections set out above to the entire course of the proceeding. That is for a quite simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery. Man, such a great word.
Skullduggery.
That would land him in solitary confinement at the Westville Control Unit, Wabash Valley Correctional Facility in Cass County Jail for 23 months pending trial.
I'm
Because
just going to
Mr.
read everybody the definition of skullduggery. Underhanded or unscrupulous behavior, trickery.
It's a great one.
Yes,
It's got a real pirate vibe, you know?
I love it.
So because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arguments that would have necessarily prevented Mr. Allen's transfer. Finally, Mr. Allen's own absence from the safekeeping proceeding should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standards trained lawyers, e.g. Zavodnik v. Harper. One consequence of this should be that the Sixth Amendment and Article 1, Section 13 of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has a right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of a criminal prosecution. And that again comes from Chronic. The safekeeping proceeding, in quotes, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all the objections to the November 3rd safekeeping order set out above, Bell v. Cone. A critical stage is one holding, quote, significant consequences for the accused, end quote. And it cannot be denied that the consequences were significant here.
And they're going to flesh that all the way out. And there's a footnote 1 there. The court need not speculate whether safekeeping proceedings have serious consequences for an accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconstitutionally kept in solitary confinement in the Indiana Department of Corrections prison and was shackled, leashed, and hooded and deprived of human contact. They cite Wolf.
But what about Walla?
They cite Wolf v. Bell for the fact that violations of due process for pretrial detainees to be kept in conditions amounting to punishment. As a consequence of that torture, Mr. Allen became psychotic. Short of his death, it is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceeding.
Okay. So, where was that footnote? Where was I? Can't find it.
Second to last paragraph, second last sentence.
Oh, I got it. Thank you. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume Mr. Allen was prejudiced by that deprivation of counsel. So alternatively, Article 1, Section 13A of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. Section 13A affords citizens even greater, I think it's supposed to be even greater protection than its federal counterpart, Caraway v. State. Not only does Section 13A guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but, quote, the rights afforded under Section 13 also attach prior to the filings of formal charges against the defendant. That's Hall v. State. And in Taylor v. State, recognizes that the right to counsel attaches upon arrest. So that answers my question, at least in terms of the right to counsel attached. I think that issue of whether or not, I mean, they had to give Allen notice. That's the fallback. Like one of the two had to be given notice.
He was under arrest.
Right. Hey, and I just want to let the mods know, I do not want you guys kicking anybody out that's like in the chat with opposing opinions, please, as long as they're
Right,
civil.
Like
Please.
Kenny Powell's. Thank you for
It's
your
actually
generosity.
a mandate, unless they're calling people names or just they're allowed to have different opinions. So just in case, and the reason I say that, I know Contrarian Dan had to come in under a pseudonym, and I know he was already firing in here, but I kind of love Contrarian Dan, so I don't want him kicked out, and he's allowed to have his opinion. We're not an echo chamber in here. I've said it, I don't know how many times. So I hope my mods are acting accordingly. So Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. This should be particularly disturbing because he had been given the opportunity to do so. Mr. Allen had what?
Had he been given?
Oh, this should have been particularly disturbing because had he been given the opportunity to do so, Mr. Allen had an absolute personal right to refuse the transfer to the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. All right, your turn to do a little reading there, Bubby.
Okay, so this is issue 2, although it's labeled 1. In violation of the Due Process Clause of the 14th Amendment and Knopp versus Illinois and its progeny, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13th, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. A conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. And that, again, is not, that's the Supreme Court watershed case on this issue. They also cite Indiana case, Smith v. State, and Stewart v. State. At trial, it is undisputed that the undisputed evidence was that LG's cellular telephone stopped moving at 2:18 p.m. on February 13th, 2017 for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McClelland called it, quote, a hard fact that LG's phone stopped moving at 2:32 p.m. The state introduced an alleged confession by Mr. Allen to Dr. Monica Walla, a psychologist contracted by the Illinois Department of Corrections to treat inmates at Westville Correctional Facility. In this alleged confession, Dr. Walla stated, Mr. Allen said he had abducted LG and AW on the south side of the Monon High Bridge and forced them down the hill to the south side of Deer Creek. Dr. Wallace said Mr. Allen said he was on the south side of Deer Creek and was planning on assaulting LG and AW when he was interrupted by a van. Dr. Walla and Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north, from the Weber property to Ron Logan's property, taking LG and AW with him. The state also introduced the testimony of Brad Weber that he left work at Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13th, 2017, and arrived home in a white cargo van at about 2:30. From Mr. Weber's testimony, the state argued Mr. Weber's arrival at home in his van what interrupted Mr. Allen, causing him to take LG and AW across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van at, quote, about 2:30 was, quote, a detail only the killer would know, said the state. But the problem is, and here you go, but the problem is the state also contended that LG and AW died near in time to 2:32 p.m. when Apple Health data from LG's phone showed the phone stopped moving. If the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him across Deer Creek, Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32 p.m. when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber could not have arrived anywhere on the property drive before 2:44:54 p.m. on February 13th. His arrival at about 2:30 could not have been a detail only the killer would know, because it did not happen. The state knew or should have known as much, and the state either elicited Mr. Weber's testimony at the time about the time he arrived home, knowing it was false ahead of time, or failed to correct that testimony once it had been elicited. Defendants Exhibit 3A, as attested to by Matthew Hoffman in Defendants Exhibit 3, is a video recording made on February 13th, 2017 by a security camera that was in the house at 5998 West Country Road, 252 North. The video recording was provided to the defense by the state and therefore has been in the state's possession. The security camera faced northwest, and appears to have recorded continuously. Based on the date and timestamp on the video, it appears that the security camera was set to record the date and time information as part of the recording. The time on the security camera was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight in the video and the associated timestamps. The security camera has a wide angled lens that captured video of traffic on West 252 North and County Road North 625 West. And that obviously, and 625 West is the private road that we're always talking about. That's the actual street. So the security camera had a wide angle lens that captured video of traffic on West 252 North and County Road North 625 West, and the beginning of the private drive to the Weber property, which begins as a continuation of North 625 West, approximately 190 feet north of that road's intersection with West 252 North. County roads North 625 West and West 652 North are the only roads by which a vehicle could enter the Weber property. According to the time and date stamps on the security camera, Exhibit 3A shows a white vehicle going north on North 625 West, entering the frame at approximately 2:44:33 p.m. on February 13th, 2017. Boom! How does one get interrupted before one arrives and 12 minutes after the everything is done and the girls are deceased? I mean, that's a pretty big bombshell.
It's a pretty big bombshell. I mean, like, you know, what was I always begging the defense to do going into trial?
Was it something with the timeline?
I don't know. It was something about attacking the timeline.
About a timeline.
So Michael in the crew here heavily attacked the timeline. So, and this is literally attacking directly what the state's theory at trial was.
I mean,
And we know from the juror that's spoken that the van had great weight. So you're saying that this link should work?
Yeah. Exhibit 3A, you might as well just wait and skip down to the second one because you'll see it better. Exhibit
Okay.
3A also shows a white vehicle continuing into the private drive to the Weber property at approximately 2:44:54 p.m. Exhibit 3B is a video file that contains 3 zoomed clips from the video recording. That is Exhibit 3A. Each successive clip in 3B is zoomed to a greater magnification. And that's of Exhibit 3. In all 3 zoomed clips of Exhibit 3B, a white cargo van going north on North 625 just after 2:44:33 p.m. on February 13, 2017. And now you can click and we can view it.
Okay.
I don't know if you want to pull up his well, no, yeah, just pull this up.
All right. So let me get it here. Wait, I got to pause it. I actually have to share this as well. Interestingly. Okay. So we'll stop sharing that. Go over here. I'm going to share screen.
I love when you talk about it while you're doing it.
Yeah, that's how I roll. All right, wait, I want to take the
Lord.
Hold on. I mean, it's as smooth as it can be, bae. It's like I can't just click it and it magically pops up.
I know, but you don't need to talk about it because then Darren needs to clean it all up.
Oh. Oh, well. Okay. All right. Here we go.
All right. So you guys, it's way, way back at the tree line in the corner of the screen.
Oh, okay. You guys see it? It's right here. You'll see it. You guys see it?
There it goes. It's going to get more obvious as it.
If you guys can see the cursor, I'm following the van there.
I couldn't see it over here in this version. I could see it in this more blown up one. The last one, you can actually watch it turn the corner. Oh no, this one, right. So the time you can't see because of our faces.
Okay.
So actually I lied and you should pull up the earlier one because now they can see the time.
Okay.
But at least they know what they're looking at.
All right. What the hell?
Oh no, they can't. It is our faces that are put us on the other side. Here, I'll get it.
Okay. Tell me when to go.
Oh. Yeah, I'm not seeing the time on this one either. Maybe it's at the top.
It's
at
the top in the middle. So I mean, obviously, if you're the state, you're challenging the timestamps, right? I mean,
right.
like
And
you would
that's
ask
the
the same
question. Is there anything that they can do to confirm that that thing's not only 12 hours off, but 12 hours and 10 minutes.
It's 8 minutes. Should I fast forward through it?
Yeah, I mean, you can just go to 243.
Okay.
So that 244. Just hit the bloop bloop. You don't want to, huh?
I fast forwarded it.
You did?
Yeah, you use the slider.
Okay, well, you're still at 242, so
Oh,
you can just bloop it instead of using the. Why are you doing that?
I don't.
Why
Wait,
are you
what?
just using the arrow?
Oh, well, because I for some reason it had pulled it up twice. What am I going to?
244.30.
244. Oh, I went way past it.
No, it hasn't happened yet.
Which one is showing?
Just let it go. It's going to come
Right.
in.
I have two of them up for some reason. That's where the confusion lies. I can't tell which one's showing because I have to be on a different screen.
All right, so there it goes, guys. It's just starting to go, and it's, just as they said, that's the time. All right, now pull up the picture of
The stills?
yeah, of the car. His vehicle. Or you can pull up the stills and then his vehicle.
Well, why don't we read through it and we'll get to it, right?
Okay.
Okay. So I think you were at Exhibit 3C.
Right.
So Exhibit 3C is a PDF with still photographs taken from Exhibit 3B at each magnification level. Exhibit 3, so for each magnification level, zoom level 1, zoom level 2, and zoom level 3, there are 3 stills showing the white cargo van. One, just before it passes the white sunlit house in the background on the west side of North 625 West. 2, as it blocks the sunlit house. And 3, just after it passed the sunlit house. Reproduced below is the first still photograph on page 3 of Exhibit 3C, showing circled a white cargo van before it passes the sunlit house on the west side of North 625 West. Okay, so you guys can see the van there.
Yep.
Okay. Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defense by the state and therefore has been in the state's possession. Photograph of Mr. Weber's white cargo van in Exhibit 3D appears to be at least similar to the white cargo van as appears in Exhibits 3B and 3C. The zoomed video clips and zoomed still photographs created from Exhibit 3A, the original security cam recording.
All right, so pull up his
Okay.
Weber's van.
All right. So you can see it. I mean, I could see it moving on the video.
Oh, I didn't realize. I forgot that we had this here, so we didn't need to actually do all of that, but because I could see the time stamp.
Yeah, so it's got the timestamp there. And then it's continuing to move. And finally, the 244.38 there. Okay.
Wait, but you have to still pull up his van.
I gotta. All right. Let me see.
3D.
3B.
D as in David.
Okay.
There it is.
I mean, certainly looks like the same van. And
Yeah, which begs the question, why are we arguing over whether, I mean, there's no way to know for sure it's his van. And at trial,
well,
they were arguing, was he even in that van?
right. I mean, aside from the fact that it was a private drive, like what are the odds that two people with two giant white cargo vans are driving on Brad Weber's private drive? Probably pretty slim. Probably pretty slim. So other video files produced by the security camera in the state's possession provided to the defense in discovery and covering the time from 2 p.m. to 4 p.m. on February 13th of 2017 do not show any other van driving north on North 625 West into the private drive to the Weber property or traveling east on West 252 North during that time. And that's exhibit 30. So exhibits 3A, 3B,
3B,
and
I guess,
3C. Huh?
Nothing. I think it's just supposed to be 3.
So 3A, B, and C reflect that if Mr. Weber returned home in his cargo white van, he could have arrived home some minutes after 2:44:54 p.m. on February 13th, 2017, 12 minutes after the time the extraction of LG's cellular telephone shows the telephone stopped moving at 2:32 p.m. Either way, or either the white cargo van shown in exhibits A, B, and C3 is Mr. Weber's, with him arriving home some minutes after 2:44:54 p.m. on February 13th of 2017, or it is not. In either event, no white cargo van or any other van entered the private drive to the Weber property after 2 p.m. and at or before 2:32 p.m. on February 13th, 2017. The time of the extraction of LG's cellular telephone shows the telephone stopped moving. I mean, it blows apart the state's timeline as to when they say that this thing took place. I mean, that was their entire timeline. That was their
Right.
entire that was how they made the connection with the Wallace statement purportedly made by Allen, and that's when they are alleging that the girls were unalived at that moment in time. I mean, it
And they
completely blows it apart.
and you're about to see how they firm up the time not being wrong on the video.
Okay. So Defendants Exhibit 3A is a redacted FBI subject information sheet for Bradley Weber and is dated March 3rd, 2017. Exhibit 3. Let me see, I got that up. Okay, so this is Defendant Exhibit 3E. And this is the Liberty German Abigail Williams homicide investigation subject information sheet. Subject name Bradley Weber, dated 3 March of 2017. The background: Weber has been staying at his parents' home in Delphi. The home overlooks and is adjacent to the crime scene. Significant developments. Bullet point: 2:02 p.m. Time card: leaving Subaru of Indiana Automotive. Bullet point: on 2/13 of 2017, Weber's phone pings to the parents' address overlooking the crime scene initially at 2:50 p.m. and it repeatedly pings around the property until 11:55 p.m. Gaps. Bullet point: did anyone reside with Weber at his parents' home in the time surrounding the homicide? Bullet point: does Weber have any physical ailments? Bullet point: does Weber have any connection to or prior contact with the victims? Okay, so the unredacted version of Exhibit 3E was provided to the defense by the state and has therefore been in the state's possession. Exhibit 3E, the FBI subject information sheet for Mr. Weber, says on 2/13 of 2017, Weber's phone pings to the parents' address overlooking the crime scene initially at 2:50 p.m. and repeatedly pings around the property until 11:55 p.m. And that's a quote. that Mr. Weber's phone first pings to his parents' address at 2:50 p.m. on February 13th, 2017 is consistent with the video evidence in exhibits 3A, 3B, and 3C, showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:54 p.m. that day.
So who exactly interrupted the perpetrator?
Right. Wasn't Brad Weber in his white van.
Nope, not if things happen the way the state said.
I mean, that's their theory. That's what they got their conviction on.
That's what they got their conviction on. It relied on that timeline and that chain of events.
And we know from that juror that the van was critical. We know it. We don't have to speculate anymore. We know that the van was absolutely critical to that jury. So
Right.
from both exhibit 3A, security camera recording, video recording, and exhibits 3E, the FBI subject information sheet for Mr. Weber, the state either knew that Mr. Weber's testimony about the time of his arrival home would be false before it was elicited, or failed to correct it once it had been elicited. When the state introduces testimony it knows will be false, or fails to correct testimony it knows or should know to be false, once elicited, a conviction must be vacated or reversed if that false evidence, quote, may have had an effect on the outcome of the trial, end quote. I wish that would have been added. What would have been added to this is a transcript of that juror stating how important the van was. Because okay, to receive a new trial, and that came from US v. Cardino, a Seventh Circuit case out of 2016. To receive a new trial is a quote, the defendant must show, one, that there was false testimony, two, that the government knew or should have known that it was false, and three, that there is a likelihood that the false testimony affected the judgment of the jury. And that's United States versus Freeman, another Seventh Circuit case out of
And this is a very, very strong argument because it doesn't rely on newly discovered evidence, although it does present evidence outside of the record, which is going to be very helpful for the appellate lawyers.
Yep. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Walla's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of the creek and unalived them. This was the only statement allegedly made by Mr. Allen that contained any detail of the unalivings that might be true. And then we've got a footnote.
Mr. Allen also said that he shot the girls in the back and buried them in a shallow grave. Neither of the girls were shot in the back, and neither were buried in a shallow grave.
The state therefore cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have, quote, an effect on the outcome of the trial, end quote. And I mean, again, and it's substantiated now, it's corroborated now by the juror saying it. Like, we know what the juror says it. The van. Alternatively, were the court to find that the state did not know or should not necessarily have known about Exhibit 3A, the security camera video, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result in a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's convictions or set this motion for hearing. I mean, this is powerful evidence.
This is powerful evidence.
It's very powerful evidence. All right, to Ron Logan's confession to Ricky Davis before May 15th, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. Okay, let me get these things lined up here. They're coming. Okay. Okay, Dr. Kaur was the forensic pathologist who conducted the autopsies of LG and AW. His original opinion, held for years, about how LG and AW died was that two weapons were used. One is serrated blade and the other a straight edge blade. For the first time at trial, having a eureka moment at his tool bench, Dr. Kaur opined that the girls could have been unalived by a single box cutter rather than two different knives.
Now, in my opinion, this is a Brady violation. That there's no way the state didn't hear this information from Dr. Kaur before he said it on the
Yeah,
on the
agreed.
bench.
It was an absolute gotcha. It was trial by ambush. It was an absolute gotcha. So Defendants Exhibit 4A is attested to by Matt Hoffman, and Defendants Exhibit 4 is a redacted copy of a tip from the Orion database of tips dated May 15th of 2017. I'm going to just pull that tip up. I don't see where the hell's, should I do Hoffman's? Should I do, I don't know if this is the right one for Hoffman's. Is that the right one?
I don't know. It should say at the top what exhibit it is, shouldn't it?
It's 3.
No, that's about the security cameras in the van.
Okay. See if you can find Hoffman's AFI on this, because I don't, for some reason, I'm not seeing it. While you're doing that, I'm going to continue to read. So Allie will find that. Let me see.
It's exhibit 4.
Yeah.
I mean, it says exactly what it says.
Let me see. Yeah, for me, I didn't have it attached to the email Kara sent me.
All right, let me look.
Let's see if you got it, because that's where I pulled all my exhibits up from. Okay, so Allie will find
I have it.
Okay, pull it up for continuity's sake, please. Thank you.
Okay.
I stopped sharing.
Okay, so he sets out that he's the investigator. Included in discovery provided by the state to the defense was a tip regarding Ron Logan's confession to Richie Davis. And it provides his provides his inmate number. At the Newcastle Correctional sometime before May 15th, 2012. 3, that tip was designated in the Orion tip file dated December 4th, 2023 as, quote, investigative thread 8578 and appears at pages 776 to 777 of the PDF of the Orion tip file. Exhibit 4A is a redacted version of that tip about Ron Logan's confession to Richie Davis. I have reviewed the original tip and compared it with the redacted tip that is Exhibit 4A. Exhibit 4A is a true copy of that. Exhibit 4B is an accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant P. Hansard about the interview with Richie Davis on June 21st, 2017 at the Newcastle Correctional Facility regarding Ron Logan's confession to Richie Davis. Those handwritten notes of First Sergeant Hansard are attached to the Indiana State Police Detective Wolf's lead narrative summary cover sheet, both of which appear in a PDF file named document2.pdf as provided to the defense in discovery by the state in Richie Davis's electronic file folder. I just laughed because
you keep calling him Richie instead of Ricky.
Oh, it is Ricky. Sorry. No, I was laughing because they named things like document 2, like, come on, talk about hiding the ball. Exhibit 4C accurately reproduces a handwritten note signed by Ricky Davis, dated June 21st, 2017. Ricky Davis's handwritten note is attached to the same lead narrative summary cover sheet and is contained in the same file as First Sergeant Hansard's handwritten notes. So the rest of it is sort of in the body, but I could pull it up separately if you want.
For what?
Like 4A.
Oh,
So
I've
this
got
is
those. Yeah, if you want to pull those up. If
Okay,
you got them,
so
pull them up.
this is the
Blow it up a little bit. That's good.
All right, so they're contacted by on May 15, 2007. Somebody contacted the FBI Public Access Line unit to report a tip on the Delphi homicide. Provided the following information. Richie Davis, again with his DOC number, is currently incarcerated at the Newcastle Correctional Facility. Business address is included. Telephone number is included. They received a call from Davis advising he is in the same block as Ron Logan, owner of the land where the Delphi homicide took place. Jenrick reported Logan is in a prison for parole violation. That was probably supposed to be redacted. Logan confessed to Ricky step by step of killing the two girls. Logan told Ricky how he burned his clothes in a fire pit and where it was located, used box cutters, and struggled with one of the girls and thought drops of blood from his nose ended up on her clothes. Ricky also advised that he unalived the older girl first. Ricky wants nothing from this but justice for the girls.
Jesus.
And then there's some more redacted information there. And then these are his notes, which they're all also in the body of this memo. Well, there's some more stuff here.
Pull up the handwritten notes.
Oh, you can't see it?
No.
Oh,
You're not sharing anything right now.
oh.
There you go. Here.
But the body is gonna have pictures of this with text.
Are you gonna try to read that?
No, it's in the body of the memo and it's typed out so that we don't have to try to do that. So you're
I
gonna
wanted you to try to read it.
I can only because I got some hints from what's written.
I was gonna say my head was gonna explode. If you can read that chicken scratch and you can't read my shit, like my head was going to explode. Like that's worse than mine.
It's closer to mine. I can make it out more.
Oh my God. Are you kidding me? All right. So you're saying that all of this is in the body?
Yeah, not this. I wonder what this is, but I wonder. So it's P, is that an E, C, and C? I wonder what that's all about. -4, -3.
I don't know.
3 months from Pendleton. He got here 2 months in 4-pod dorm originally, rec line together. He wanted to set up JPay account, helped him with that. Started talking, uncomfortable circumstances, custody, talking about it in the beginning, modifying county charges, etc. And then the rest of this is all in here. So go ahead, pull up your thing because it's gonna go through all of it.
Okay. Okay, so I'll start there.
I don't know if everybody else knew this. I did not know this. I did not know Ron Logan confessed to using box cutters. Like my jaw dropped when
I didn't know it until I knew it. I didn't know it before trial. So Defendants Exhibit 4 is attested to by Matt Hoffman. Defendants Exhibit 4 is a redacted copy of a tip from the Orion database of tips dated May 15, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Ricky Davis sometime before May 15, 2017, while they were in prison together, that he had killed LG and AW. The material part of Ron Logan's confession to Ricky Davis, as it appears in Exhibit 4A, is reproduced below. So Logan confessed to Ricky step by step of unaliving the two girls. Logan told Ricky how he burned his clothes in a fire pit and where it was located, used box cutters and struggled with one of the girls, and thought drops of blood from his nose ended up on her clothes. Ricky also advised that he unalived the older girl first. Ron Logan's confession to Ricky Davis, as reflected in the tip in the Orion database and made a mere 3 months after the girls were unalived, was detailed. Law enforcement followed up on the tip. Defendants Exhibit 4B was attested to by Matthew Hoffman. In Exhibit 4, accurately reproduces the handwritten notes taken by the Indiana State Police First Sergeant P. Hansard about his interview with Ricky Davis on June 21st of 2017 at the Newcastle Correctional Facility regarding Ron Logan's confession to Ricky Davis. Those handwritten notes of First Sergeant Hansard are attached to the Indiana State Police Detective N. Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of his interview with Ricky Davis about Ron Logan's confession provide even more detail. Okay, so hard as they are to decipher and subject to debate and correction, those notes reveal the following about Ron Logan's confession to Ricky Davis. Page 1 of Exhibit 4B is reproduced below. So you're saying that they try to, okay, it seems to say, talking about knowing one of their dads, to walk with them. One of them wanted to turn around, grab the youngest shoulders. It's okay. Oldest freaked out. One said something about calling police. SA wasn't true, originally not trying to R them. Paranoid about probation. Felt like he crossed the line when he grabbed the youngest one. The top half of page 2 of Exhibit 4B is reproduced below. The bottom half of the page duplicates the top half. Okay, it seems to say he started talking. Ironic, should have been in school. Knew one of their moms, waitress at a bar. Animals, walked with them, willing to check out horses. Plus he, XXX, he told them he had rabbits in the barn. Walked through the trail in the woods. Oldest paranoid, didn't want to go. Youngest wanted to see the horses.
So scroll up because I think I could make out where they have the XXX.
Okay.
So
up further.
No. He started talking. Ironic, should have been in school. Talking to them, knew one of their moms, waitress, out at a bar. Animals, walked with them, willing to go check out horses. And he started maybe. And he said he told them about that he had rabbits.
That's longer.
Yeah.
It said, I don't know.
But I mean, it gets the point that he told them he had rabbits in the barn, walked to the trail. The oldest got paranoid, didn't want to go. Youngest wanted to go see the horses. Yeah, so they got it all.
Yeah. Top half of page 3 of Exhibit 4B is reproduced below. Oldest, it seems to say oldest turned to help youngest. Oldest started looking, kicking. Oldest started.
Yeah, it could be looking or kicking. Looks.
Yeah, it could be either one.
Wait, I'm going to look on the other side.
Youngest seemed
maybe shaky. What did they write?
Nothing. Seemed, and then there should be an XXX there. Shaken. Youngest seemed, talking about right here, y'all. You can see it. It's definitely an S word. Looks like an SH. Okay. Oldest started looking kicking. Youngest seemed ? He now grabs oldest. He said he got hit on the nose, scared he got blood on one of the girls. Pulled box cutter out and slit oldest one, hit an artery. Youngest scared, etc. Took little girl with them for a while, never said where. He said he cut her to both necks. Said he cut her to both necks.
That's it. It literally says he said he cut her to cut both necks.
Okay. He said he cut her to cut. Okay. The bottom half of page 3 is produced. Okay. It seems to say he left again, came back later in the evening. Search going on. Later on, late hours, tried to move oldest one to an area not going to be found. Place where four-wheelers go. Burned his clothes in a burn pile. Hiking, walking boots, gloves, and a bag. Wow. Top half of page 4, exhibit 4B is reproduced below.
Looks like old sores. I guess it's not, though. Something of boots.
Oh, it looks like it says, could sole of boots be located in burn pile? It's a note. It seems to say sole of boots be in burn pile. And I think that was like an inquiry to himself. Could the sole of the boots be located, I'm guessing, in the burn pile? Next morning, 2 other girls knocked on the door, asked to search the property. Feel weird if he said no. He let them take off. Got a hold of family member and got out of area. Wow. This is like crazy.
It's so crazy.
The bottom half of page 4 of exhibit 4B is reproduced below. It seems to say the first time he seen them from the property, home, etc., guns, etc. During struggle, youngest girl, not. First time he's seen them from the property.
Does that say horse?
Here?
House?
House?
Into, etc., guns, etc.
It's hard as well. During struggle, youngest girl.
I mean, it looks like an H, but it doesn't make any sense.
It looks like a SH word, not.
It could be scared, not mug. I mean,
yeah, but it looks like there's a period after it, like it's
short for something. Yeah.
Happened by friend.
Not message.
Happened to friend.
Phone. I don't know.
Struggle. During struggle, youngest girl, unknown, not unknown, happened to friend.
Did they write? Yeah, happened to friend something to stand there.
Happened to friend. Man. Head, neck, artery. Jeez. Well, like my mind is blown.
Yeah.
So how was Ron Logan cleared?
It doesn't make any sense. And then they decide he was killed by a box. They were killed with a box cutter.
And
is this a sick joke? Is this a sick joke? Everybody should feel bamboozled. And people who are saying they don't feel bamboozled are just liars, just blind liars. That is not a coincidence.
How did they clear Ron Logan?
He's deceased.
No, so that's not clearing Ron Logan. How was Ron Logan cleared?
I mean, that's what I was saying, that maybe they just cleared him because they wanted to convict someone.
That's not clearing somebody, right? That's a different thing.
Well, I know.
This
I'm just
is-
saying
This is outrageous. Like this alone, in comparison to the alleged confession by Richard Allen, like where's this Ricky Davis? Is this guy alive? Oh my God. Defendants Exhibit 4C is a handwritten note signed by Ricky Davis dated June 21, 2017, the same day First Sergeant Hansard interviewed him. That handwritten note is attached to the same lead narrative summary cover sheet and is contained in the same file as First Sergeant Hansard's handwritten notes that are Exhibit 4B,
This
Exhibit
begs the
4.
question, why, as soon as this guy mentioned box cutters, the defense should have been saying that they opened the door and they're, to reassess the third party culpability, barring that they're not allowed to talk about Ron Logan. I mean, that made Ron Logan, if that's not a nexus, I don't know what is.
I mean, what you mean that's his property that they were found on?
No, that he said that he killed them with a box cutter, and they just put on expert testimony from the ME that he thinks the murder weapon was a box cutter. Now, they should have asked the court to allow evidence about this specific evidence.
And it was on his property.
Well, I know there's all those things as well. I'm just saying.
And he was there.
And the FBI said he looked like the guy. That was their first determination, that he was Bridge Guy.
All right. Do they translate this for us?
Yes.
Okay. Okay.
Were you looking in the memo or are you looking at the document?
I had Ricky Davis's handwritten note up. Okay, this is it. Ricky Davis's handwritten note about Ron Logan's confession to him says, Mr. Logan has made references to the unalivings in Delphi, Indiana. He told me he was the one who had unalived those girls that had got out of hand. He walked with them in the woods to his property, and the girls wanted to turn back. Said something about walking the blank. He grabbed the youngest girl to reassure her it was okay. However, they panicked, and he also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he unalived both of them because it took too far. I want to see if I can figure out what that.
I think that he didn't say. Like, I looked at it. Like,
girls.
Wait.
I'm talking about that one.
Right.
He grabbed the youngest to reassure her. Panicked. He also panicked.
No, it's up higher. You're not there yet.
Here?
Oh,
I've got the letter up. What are you looking at?
No, I thought it was, I don't know. God, I thought the blank was like.
He walked them both into the woods to his property. Something about.
Said something about walking. Go back to it.
All right. The girls wanted to turn around and said something about calling the police.
That's what it says. Yep. Not walking anywhere, calling the police.
And said something about calling the police.
He grabbed the youngest girl. So he
said something about that definitely says what I'm saying. It says.
Yes, it says about calling.
It said something about calling the police.
And I thought some of those other words in the earlier one were calling as well.
This is definitely calling the police right here.
Yes.
Wow. What the fuck? So in addition to the other details that fits the known facts, Ron Logan confessed to Ricky Davis that he used, quote, box cutters to unalive the girls. If instead of, for the first time at Mr. Allen's trial, Dr. Kaur said 7 years earlier, said the girls could have been killed unalived by a box cutter, there would certainly have been probable cause to arrest and charge Ron Logan with the girls' unalivings. As it was, the FBI, 2 months before Ron Logan's confession to Ricky Davis, had obtained a judicial finding of probable cause to search Ron Logan's property. Under the circumstances, Dr. Kaur's trial testimony about a box cutter possibly being used to unalive the girls makes Ron Logan's confession to Ricky Davis newly discovered evidence that would either be admissible through Ricky Davis, and that's Indiana Evidence Rule 804B3, or through First Sergeant Hansard under the Due Process Clause of the 14th Amendment, Holmes v. South Carolina, 2006 Supreme Court case, or Kupch versus Neal, 7th Circuit case out of 2016. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at retrial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. Dude, what?
Crazy.
What?
Crazy. It's like,
What?
I just don't believe anyone who continues to say they're convinced.
I don't care about those people. Like they have zero credibility to me. They ring the pathos. They
No, I just mean anyone who has
it's
been
pearl clutching. Like they have nothing to say. None of them will debate us. Like none of those people mean anything. They're all just full of shit. Anybody who's willing to debate and come on and argue the facts of this case, I'll respect them. Anybody who hides and just writes articles or puts out hit pieces, they got nothing. They've got nothing to say. Like they're not willing to back up. They have there's nothing girding them to their position. They've whatever. Oh, this infuriates me. This infuriates me. How was Ron Logan cleared? Does anybody in the chat know? Michael, how was Ron Logan cleared? I'm dying to know. Because we all knew about him lying about his alibi. He'd gone to the fish store.
Was that Logan too?
Yes, it was Ron Logan. God. I mean, Barb McDonald has always thought it was Ron Logan. Always. Always.
So did his ex-wife or something?
Ex-girlfriend. Yeah. I mean. All right. So
what a fucking catastrophe of justice.
All right, Defendants Exhibit 5, the affidavit of Stacey Eldridge, states that the dirt or water damage to the phone could not have caused the auxiliary jack on LG's phone to log wired headphones plugged in and wired headphones unplugged. Ms. Eldridge's expert opinion is newly discovered evidence that would probably produce a different result at a new trial. Now, this is a strong argument because
it's a strong argument, but for the newly discovered part.
Well, but it is because of the fact that
it was trial by ambush.
It was trial by ambush, and it was the 15-minute Google search. Now, I mean, the state's counter argument is going to be that Eldridge should have
presented this at trial in rebuttal.
What?
That the defense should have presented this at trial in rebuttal.
Well, I think that's the point, that she didn't have time to do it. But it was
okay.
I guess they could have come back the next day
when newly discovered,
right?
Yeah.
So, Defendants Exhibit 5, the affidavit of Stacey Eldridge, states the dirt or water damage to the phone could not have caused the auxiliary jack on LG's phone to log wired headphone plugged in and wired headphones unplugged. Miss Eldridge's expert opinion is newly discovered evidence that would probably produce a different result in a new trial. That's hard to say. I mean, like the juror didn't seem to give any credence. However, had she been able to rebut it, I find it impossible for jurors to disregard the fact that
it was very powerful.
It was very powerful, but seemed to land with a giant thud.
Only because of this
right
Google search. So absent that, it was like boom.
Yeah. At trial, Mr. Allen introduced evidence through the testimony of Stacy Eldridge, a digital and mobile forensics expert, that someone plugged wired headphones into the auxiliary jack of LG's phone at 5:44 p.m. on February 13th of 2017 and unplugged it at 10:32 p.m. the same day. To counter this, the state offered the results of a seat of the pants Google search by First Sergeant Cecil, the state's phone expert. According to First Sergeant Cecil, the Google hearsay told him in his expert opinion the log on LG's cell phone showing wired headphones were plugged into that auxiliary jack at 5:54 p.m. on February 13th, 2017 and unplugged at 10:32 p.m. that same day. Could have been caused by dirt or water damage to LG's cell phone. The defense had no opportunity to counter First Sergeant Cecil's, quote, expert opinion, courtesy of Google. The court should read Miss Eldridge's affidavit, Exhibit 5, in its entirety. But the short version of Mrs. Eldridge's actual expert opinion is, I'm going to actually read it.
Okay. Now, while you're pulling that up, I just want to note that not only is his hearsay expert Google opinion, but it's not even an opinion that Cellubrite is going to falsely identify it like that. You know, like even if there's something that they're saying that this could happen with a phone that gets dirt in it, that has no bearing on what an extraction report of the phone will consider it. And
Wait,
that
are you
wasn't,
saying that Cellubrite will not log like false positives?
we don't know. That's the point. What he testified to had nothing to do with what a Cellubrite report is going to say. It's just that he believes that it's possible that they're saying that your like your sound won't work because maybe the phone thinks something is plugged in, is what a thread of people talking said, but not that has any bearing on an extraction report and on the internal data of an iPhone, as opposed to the functionality of an iPhone. That's completely two different worlds. It should have been stricken. It should have been a request for a mistrial. It was outrageous. And this is just, it's infuriating because,
I mean, Jennifer was furious.
what's likely going to happen is a whole lot of nothing, despite all of this.
And why do you think that? Because it's not newly discovered evidence? Do you
No,
not think
because that's just the way the law cookie crumbles. That's what happens. People don't care about truth, justice. It's form over substance. And yeah, it's not newly discovered. Like in Illinois, I would be telling my client, fire your attorney and bring in a new lawyer to assert a post-trial motion, ineffective assistance of counsel for not somehow getting this in at the time of trial. But obviously that's easier said than done. Yes, she needed time. Everything's happening all at one time. And it's super easy looking back with foresight of 20,
hindsight. Yeah.
hindsight.
So, all right, let's go through Eldridge's affidavit. Comes now Affy and Stacy Eldridge under the pain of penalty of perjury, and states as follows: I am over 18 years old and competent to testify.
Yes. Come on, get to her.
2, I received my Bachelor of Science degree in Management Information Systems from Bellevue University in 2001. 3, I received my Master of Science degree in Computer Information Systems from Bellevue University in 2008. 4, I provide digital forensic and mobile forensic services through my business, Silicon Prairie Cyber Services, LLC. 5, I am an adjunct professor at the Oklahoma State University Institute of Technology, where I develop and teach digital forensics and mobile forensic courses. I also teach cybersecurity courses. 6, I am also an adjunct professor at Bellevue University, where I teach cybersecurity and digital forensics courses. 7, I was the director of cybersecurity at Lincoln Electric System from 2017 through 2019. 8, I was a senior staff cyber investigator and program manager at General Electric from 2012 through 2017. 9, I worked for the FBI from 2003 through 2012 as a digital evidence instructor and a computer analysis response team senior forensic examiner. 10, I have the following certifications relevant to digital forensics. A magnet certified forensic examiner. B, IACIS certified mobile device examiner. C, an IACIS certified forensic computer examiner. D, a GIAC certified forensic examiner. E, a GIAC security essentials certification. F, a GIAC critical control certification. G, FBI certified computer analysis response team senior forensic examiner, FBI. H is a FBI certified computer analysis response team forensic examiner. I, FBI certified PDA forensic examiner. J, FBI certified cell phone forensic examiner. K, Celebrate UFED certification. And L, access data certified examiner. 11, I have previously served as an expert witnesses in the following cases, 3 of which are all federal cases. A, United States of America versus Kelly Edward Wadford. B, U.S. v. Yusuf Samir Megahead. C, U.S. v. Dante James. And D, of course, State of Indiana versus Richard Allen. 12, data from Liberty German's phone 6S, iPhone 6S showed that wired headphones were plugged into the phone at 5:44 p.m. Eastern Standard Time on February 13th, 2017, and were unplugged at 10:32 p.m. Eastern Standard Time on February 13th, 2017. This was the only evidence of any wired headphones ever being plugged in and removed from the phone. 13, Apple's iPhone 6 were equipped with sensors to indicate water damage. 14, there was no indication in the data from Miss German's iPhone 6S that indicated the sensors identified water damage to the phone. I would expect to find evidence of the water damage notification that is displayed to the user to be present on the iPhone. 15, I reviewed the following extractions and reports produced by the state of Indiana in discovery in this matter. A, Celebrate logical extraction report and data created by Indiana State Police First Sergeant Brian Bunner on February 15, 2017. B, the Celebrate Method 1 through 3 extraction report and data created by the Indiana State Police First Sergeant Brian Bunner on October 12, 2017. C, digital forensic examination initial report created by ISP First Sergeant Christopher Cecil on August 21, 2019. And D, digital forensic examination supplemental report created by ISP First Sergeant Christopher Cecil on August 18th of 2024. None of the above reports or extractions contain evidence of dirt or water damage to Liberty German's iPhone 6S, nor did they indicate that it was particularly dirty or covered in debris. I reviewed photos of Liberty German's iPhone 6S taken by the Indiana State Police. A, the phone does not appear to be wet, dirty, or covered in debris in any of the pictures, which McClellan literally said, "Oh, there you can see the phone. It's dirty and wet," like in his closing argument. B, no pictures were taken of the phone displaying a message indicating the liquid had been detected. C, no pictures were taken of the control center of the iPhone 6S to document that the headphones were being reported as being plugged in when they were not. 17, I reviewed the chain of custody for Liberty German's iPhone 6S, and it did not document that it was received in wet, dirty, or damaged condition upon receipt. 18, iPhones that have recent water damage are known to reboot spontaneously, requiring multiple attempts to complete the extraction with a forensic tool. No instances of this were documented or reported by the Indiana State Police. 19, I am currently unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6 would cause the iPhone to inaccurately log wired headphones in or wired headphones out. She affirms it there.
What's frightening to me is that she does say that a water damaged phone is known to reboot spontaneously.
Oh, meaning that if it had been water damaged and had crapped out, that it would have rebooted? Or would have tried to reboot?
Yeah.
Yeah, but see, the thing with the 6S is that they had that. Remember how we were
I
talking about?
understand, but she didn't examine the physical phone.
Yeah.
Boy.
Okay, so the court should read her affy in its entirety, but the short version of the actual report or the actual expert opinion is
We don't need to read the short version. We just read the long version.
okay. According to the Apple Health data on LG's iPhone 6, the phone stopped moving at 2:32 p.m. on February 13, 2017. At trial, the state contended LG and AW died close to that time, and AW hid the phone under her body before she passed away. The state also provided testimony by former Delphi Police Chief Steve Mullen and ISP Lieutenant Jerry Holman that there was no evidence that Richard Allen returned to the location where the bodies were found after allegedly being spotted by Sarah Carbaugh on CR 300 North at approximately 3:50 p.m. on February 13th, 2017. If Miss Eldridge's actual expert opinion that wired headphones were plugged into LG's auxiliary port at 5:44 p.m. on February 13, 2017, and unplugged almost 5 hours later were credited by a jury, the state's narrative is impossible. Someone other than Richard Allen was handling LG's phone multiple times long after the state contended Mr. Allen left the scene before 4 p.m. on February 13th of 2017. Miss Eldridge's opinion that the dirt or water could not have caused LG's phone to log wired headphones being plugged into and being unplugged from the phone on February 13th of 2017 exculpates Mr. Allen and would probably produce a different result at a new trial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. The matters set out and attested to above, taken individually or cumulatively, entitle Mr. Allen to either have his convictions vacated or to have a hearing on those matters set. Conclusion: for the foregoing reasons, Mr. Allen respectfully requests that the court either vacate his convictions or set the matters above for hearing and for all other just and proper relief in the premises. So it was submitted by the three attorneys and it was penned by Michael Ausbrook. Well, wow, sneaky.
Barb, I wonder if Barb's saying anything or she's just here.
I love you.
You know, it's just, it's not supposed to be a chess game. It's just not. But that's what it is.
Yeah. I mean, I don't know if chess game is the right analogy. I mean,
Whatever. It's a game, and truth doesn't matter.
right. No, it's more like 3-card Monty is
Yeah.
what it's like. You know, that's what it is. It's a con is what it is. You know, look, I knew this was coming. I saw it in various forms as it was being produced, and my mind's blown. And I'm just going to say it, and you already kind of threw it out there. Is shocking is what we've just read to you is. And if you don't find any of this even remotely disturbing, I don't know what to tell you. And Dan, they did try to use Ron Logan as a third party. You're incorrect, sir. They didn't go into the detail that they did with Kagan Klein at the 3 days of hearings, but Ron Logan was absolutely brought up.
Well, but why wasn't this connection shown? Well, they didn't know about the box cutter, so. But
Point being here, like I don't want anybody to be shocked. You've been following this case with us for 2 years plus at this point. You know what Judge Gull is going to do. She's going to deny the
nothing. She
motion.
doesn't even think he's got any mental health issues.
Right. She's going to deny it without hearing. And you know, they made a record. Now, I mean, the issues that are going to be brought up are what Allie keeps talking about is this truly newly discovered evidence? That's
Well, the Brady violations, there's a Brady violation, I think, with the doctor saying that the box cutter, and there just has to be able to be a logical, argument made that this should be considered newly discovered under circumstances where the state withholds evidence until trial, presents false evidence, and people aren't, it's again not supposed to be a game about whether the lawyers could respond quickly enough to pull together something that might not have seemed relevant at all until the state dropped new information at trial.
yeah. So like the interplay with the appeal that's forthcoming, I like none of this is really going to be able to be raised in the direct appeal, right? I mean, aside from the arguments that Ron Logan was a named third party suspect of theirs, I mean, that like they'll be able to get some argument as to that in. In theory, I guess the question becomes, even if they had allowed, like I would have to assume that had she not shut the third party culprit stuff down, they would have discovered this. Like I'm hard pressed to think that if Andy had produced that information about Ron Logan and his purported confession that had so very many details, that Gull would have been able to say that there was no nexus there.
Not after the guy, even if she could, not after the ME testifies that he believes that the murder weapon is a box cutter.
Right.
I mean, that's like, mm.
I mean, where's Ricky Davis?
They don't need him. They have what he said. It's right there. I mean, not for the purposes of this memo. I mean, this petition motion. There's Michael's prediction.
Where
no hearing in the Court of Appeals has to assume it's all true.
Wow. Well, I can only assume that as this starts making its way out to the world, people are going to, people are going to have strong feelings about it. I just think that people have to temper what their expectations are going to be as a result of it. It's like we've said it a million times. It's like it's the frustration with the system is that once you are found guilty in this country, it is damn near impossible to undo it. Damn near impossible. And like in recent memory, I don't know if ever I can remember a case that post verdict. And look, I'd love to take credit that it was you and I that created this huge amount of people that just doubt this conviction, but I can't do that because
No.
I refuse to diminish the intelligence of the people that follow this case and form their own opinions. I mean, like to me, if you're being honest And I invite any of the pro-guilters to our channel to have a spirited civil debate about it. It's a standing invite. Always. Any of them. Brett and Alice, Kevin and Anya. What's his face?
Box cutters, he said.
Gray
cutters.
Hughes, Sleuth Intuition. Any of them. I'm not hiding from anybody. I've never hidden from anybody.
Who said
Not my style.
Who said you were hiding? What are we even discussing?
No, I'm implying that they're all hiding. I don't hide. Do you hide? We don't hide.
I'll hide.
I want to hear how people on that side, based on the evidence that was presented at trial, are going to be able to sit there and say that with as much confidence that you can have in a verdict, in a case where it's all circumstantial, that none of what they've just been exposed to causes them even the slightest concern. It's just disingenuous. It's just a shitty way to be. It's just like those people that say that they care about justice for the girls are so full of shit. They just want somebody arrested and convicted and to put it away. Like, if this doesn't disturb people on that side, I don't know what to tell you. Then you don't give a shit about due process in this country. I don't care what you say, and I don't care what you do for a living. And you don't care about the Constitution. Like, there is no counter argument to that. If this is not this all, again, is not made up by the defense. This is all shit that was contained in the state's discovery. I invite Jerry Holman to come on. I invite Nick McClelland to come on. Answer some questions. Or are you going to sit there and just break your arm, patting yourself on the back for what appears to me to be a very specious conviction? If you're so confident in it, come in. Come hang with us. Let's talk about it. Maybe you can explain how Ron Logan was cleared, which I know
And how he
from my friend Dan Samatovich.
unaliving the girls with the very murder weapon that the ME says was the murder weapon.
Well, worse than that, he puts on a witness who he knows is going to say that was in fact the murder weapon, knowing that this exists in the world.
Right.
It exists.
It's dumbfounding to me. Like, I don't understand. Look, there are a lot of facts that the lawyers need to know about this. Ron Logan wasn't going to be allowed in. Ron Logan had been cleared. He's not, I don't know, was he not necessarily tied to all the Odin stuff, or was he? Did he have any tie?
So Dan, my buddy Dan Samatovich he's got The Deviant, and I've had him on a couple times. He's telling me, it's like watching your live stream every time we asked law enforcement. So he did the Down the Hill podcast with Barb.
Right.
Every time we asked law enforcement, they never had a good answer for why Logan would proactively invent an alibi per the probable cause, per the PC, for a crime that had not yet been discovered, for the exact time the crime was being committed. That's the big question for me. Logan was never cleared officially, and that's per Dan. And back when they were doing it, down the hill, I mean, they had relationships with law enforcement. Like Barb was able to talk to these guys. Barb interviewed everybody. I mean, Barb, I don't know if she'd be upset about me saying, joke. I mean, Barb has always thought it was Ron Logan.
God,
I mean,
no
she
one
said
tells
it.
me.
I mean, I think she said it on our show. Like she is, you know. Wait, is that true? 1,900 watching and 650 likes?
Come on, people.
Seriously,
Come on, people.
for real. Please, like, help get us out in the algorithm. That's what that does when you hit the little like button, which is free. It's free. Just hit the like. It helps get our show out. We have a good show. Give you guys some straight dope. Give you some just facts. So
Lawyers can't be expected to recall every detail of every tip and what everybody said and every this and every that when the state surprises them mid-trial with new testimony.
I mean, but these are going to be issues that are going to be raised. They're problems. They're problems. And you're right. Like it's like us saying that there's potential ineffective assistance claims here is in no way
Really
besmirching
saying that they were
my
ineffective.
friends
Right.
who I thought did the best that they could with everything that they were up against. I thought they tried the case as well as they could. But like you said, I've never walked out of a court of law after a trial and not been like, oh my God, we didn't get this in. And like you give me like anxiety attacks. Like as soon as we're walking out to the, you're like, oh my God. And I'm like, what? And you know, and you'll be like, we forgot this. And I'm like, oh my God. I'm like, it's not like, that's not a, like you're dying, taking your last breath type of gasp situation, Allison. You're like, you know, it's like, you're always going to do it. You're always going to do it. You know, and the question's going to become, so as this thing proceeds through the appellate process, because again, if you think, I'm going to try to walk you back. If you're at that ledge where like, oh my God, like Gull's got to read this and she's got to have at least a hearing, and maybe she'll even contemplate doing the convict. Neither of those things are happening. Okay, so it's just his convictions are not going to be vacated. She's not going to have a hearing. This is going to get denied.
It's going to take forever.
But it's important because it establishes the record. It creates the appellate. It's all for the record.
And hopefully the appellate attorneys will fight even harder seeing so much evidence that it exculpates him.
Yeah. I mean,
or creates reasonable doubt. I think we can all agree that this creates reasonable doubt. Some doubt.
oh, well, you'll be happy to know Kathy Shank cleared Ron Logan. Kathy Shank cleared Ron Logan after Richard Allen was arrested.
Wow. That was so thoughtful.
Wow.
So helpful.
That was courtesy of Sleuthy. Man, it makes me sick to laugh, but it's like at this point, I don't.
Is that her friend? Judge Jessica says that's her friend.
Who?
I'm
Whose
assuming
friend?
Kathy Shank's friend is Ron Logan. I don't know, unless I'm taking these at a.
I don't know. I don't know. I mean, that is, you know, Michael kept asking me, he's like, does this track? I mean, it tracks, man. It tracks. It's I mean, I think that the three kind of main thrusts, the destruction of the timeline, unequivocally, the state's timeline, again, if anybody wants to come on and debate me how that does not destroy what the state's timeline presented at trial was, I'm here for it. Come and tell it to me. Explain it to me like I'm 5 years old, because that's what that just did. That document that I just read broke it down as if I were a 5-year-old, how the state's timeline in which they used to convict Richard Allen was just exploded. The things that they relied on, which more than anything, maybe even more than the van was the fact that Libby's phone stopped moving at 2:32 p.m.
Yeah.
Like that was their thing. They're like, you know how we know they're unalived at that point in time? Because her phone stopped moving. That's how we know. That's how we know.
Yeah.
So, and the next two things, it's like I don't even know how to do the interplay. Like Ausbrook should come back on. Like when you're considering whether or not to put on, I'm curious, Michael, in terms of kind of what to begin with. How did you determine? I mean, obviously, like the safekeeping stuff, like procedurally, obviously, I think made the most sense coming first, and it's a powerful argument, man. Like I don't, you know, Alice and I have debated what kind of, but you know Indiana law better than we do. That's for
Well,
certain.
no, his legal argument is sound that hearing, like I said, proceeding is invalid, unconstitutional, unlawful, should have never happened. He shouldn't have been transported. The question just becomes, will they follow that to the lead to the end to say that harm because of what followed is responsible for that and, you know, warrants reversal. I
And
mean,
I guess my question to you would be how can it not be viewed that way? I mean, what happened in Westville happened. It's of record. It's like the guy went into psychosis. Hey, what's up?
I couldn't get to him. It's like the bottom of my screen is,
Hang on, I gotta turn off the speaker.
it's weird. Oh, now it's letting me scroll. Okay.
Oh, you mean when we get somebody down low? Yeah.
Yeah.
I think, I am loath ever to say that either of the women, Allie or Kara, misunderstand anything, but I will say that I think maybe Allie's thinking of the chronic claim in a little bit the wrong way, and that is, it doesn't matter what happened later and tying it up. It is, if you have once you've established there's a critical stage, in other words, these kinds of hearings have serious consequences for the accused. That's Bell v. Cone or Cone v. Bell. There are a series of the Bell v. Cone things coming out of Tennessee. I always forget which is which. Once you've established it's a critical stage and there's no lawyer, it's over. And that's because chronic says it's not worth the cost of trying to figure out what would have happened if it had been done right.
Yeah, but has that ever been applied to this type of hearing?
I have the research that shows that I have bail hearings. That's conditions of custody.
Well, if they're reversing convictions for not having counsel at a bail hearing, well then, yeah, I've been thinking about this completely wrong.
Well, look, the basic thing is, I mean, so serious consequences. That's one gloss for a critical stage. The other gloss is whether you have and I hate the phraseology, the guiding hand of counsel. Another is where you're confronted with the adversarial forces of the state. Safekeeping hearing fits all of them.
Right, but typically, I guess the reason I think of it like that is like typically it's like, okay, so he didn't have counsel at that hearing. What was the impact on what happened? He got
and I'm saying, I mean, the impact is fine. I'm sorry, I'm gonna interrupt you. The impact is fine. The impact has no place in the analysis.
Right.
It's just over. It's like, so there's this chronic case I had. It was a sentencing hearing. actually out of Gull's Court in the Seventh Circuit. And there was a lawyer there, but he didn't say anything, so he was effectively absent, right?
Right.
And it was just because he was effectively absent, he gets a new sentencing hearing.
Right. So that's what I'm saying. He gets a new sentencing hearing. So what's he going to get, a new safekeeping hearing?
No, he gets a new trial because he gets a new trial. And it's just the same. Yeah, it blows out the whole thing.
But is that because of the fact that bridge has been crossed with respect to a new safekeeping hearing, right? So like Allie's question is based in the fact that, like, look, okay, pre-trial, pre-conviction, obviously they can cure it by conducting the hearing properly. Here, Michael, I think you're saying that can't be done. This is like the ship has left the port. He's been convicted. So the only way to cure it is to give him a new trial.
Right. And if you're putting, for instance, if you're putting an unconstitutional, you don't have counsel, you have the right to counsel the lineup actually pre-trial.
Right. So then they toss out the lineup.
Well, if they toss out the lineup if you object and the rest, but if you don't, you go to the end of the trial and they put the lineup in, I think it's a new trial, period. And I don't think you have to go to ineffective assistance for not trying to get the lineup pitched out. Yeah, look, it's an argument. I'm not saying it wins. I'm saying
I hope it wins. I just, I'm very obviously skeptical of the law,
Well, these chronic cases are actually rarer than hen's teeth, and it's because it just doesn't happen that people don't have lawyers at critical stages. It really doesn't.
Right, because the penalty's so strong. Your case gets lost.
Yeah, there could be a deterrent effect there. When I was doing that case in the Seventh Circuit, it's very hard to find chronic cases.
Well, because some of the arguments, like, he didn't have access to his counsel, but don't you need to take that to the next step and say, how did him not having, contact with his counsel easily affect the counsel's ability to do their job? It would have to be something like, well, we were so limited in the amount of time, we weren't able to show him this one thing that had he been closer and we've been there more often, we would have actually showed him, and then we would have known X, Y, and Z. I don't know.
Yeah. No, this is not about access to counsel. So you might have later, and in post-conviction, a state interference with counsel claim, and we were thinking, I was at least thinking of pitching to the lawyers, raising that in this, but A, there wasn't time, and B, I think there needs to be a better record. And yeah, the state interference with counsel claim is there for that, but this is not about access to the lawyers in prison. This is about simply not, it's just like a sentencing here. The whole thing goes down.
Do you think that this petition incorporates a Brady violation for the for what is the Coors testimony about the box cutter?
I mean,
yeah, I think I view it more as a discovery violation, not a Brady violation.
Well, the reason I think it could be Brady is because it does exculpate him, because it implicates someone else by making that nexus that wasn't there without it. As far as he confessed to using the murder weapon that they presented evidence was in fact the murder weapon, something only the killer would know.
Well, yeah, there are a couple of things I'm not going to say, but I don't know that it's so. I think it's inculpatory of Logan, but I don't know that by itself it's exculpatory of Rick.
I mean, they do extend Brady to anything that's going to be, helpful to the defendant, and it would definitely be helpful.
Well, it wasn't helpful at like it would have been helpful to have it. Yeah, it's hard. It's hard to
Even
draw
2
the
days
direct.
before they said it, so that the defense could have, processed it, had some time to figure out that this connection, and then made some sort of argument that they opened the door, and that they now have the nexus that she thought was lacking, even though the
I
argument
mean,
is
there's going to be language in the transcripts when the trial transcripts are prepared, because I can't remember if it was Brad who crossed core, but it definitely, when the box cutter thing came out, um, I think I think it was Brad. It may have been Jennifer though, and it may have been in one of the hearings that I first saw at core. I can't remember, but they definitely asked him, "Well, did you prepare?" And I think it was a trial. Did you prepare an addendum to your report indicating anything about this epiphany of yours regarding the box cutters? And Core's like, no, I didn't. And so there was quite a back and forth there. I think that I don't know how that interplays with a Brady violation, wherein Core didn't add it to a report, which he should have, especially if the state was going to rely on it. And if the state knew that they were going to rely on it, there should have been a disclosure of some kind.
Yeah, they have to disclose opinions ahead of time. That's why I see it as a discovery violation. I'm not sure. It may be frameable as a Brady violation. It comes up at trial. I don't really think of it in those terms, but they should have, like when it came up, yeah, they should have been asking. And again,
I read a case that it can constitute a Brady violation if they withhold it until it's too late to be useful.
Yeah, and it's possible, and hold too late would be sort of interesting question to find out. When the prosecutors knew about the Core was going to talk about box cutters.
I can't imagine anyone would believe that the first time they ever heard the word spoken is on the stand. But you would need a judge who's willing to call out that, impossibility as being them trying to, like, who do you think you're shitting?
Yeah, well, as I said earlier, right? All you can do is pitch up the arguments, get in the evidence, stuff the appellate turkey, as they say, and see what happens. We should talk later. I mean, I agree with you that trials should not be chess, but there's at this point there is a chess aspect to this, and
Yep.
Michael, you said a couple of times that it's like you don't necessarily think that that's exculpatory to Rick Allen, but I think the counter argument to that is that if you're pointing the finger at somebody else by way of that, and it's with credible, admissible evidence,
yeah,
that is exculpatory to Richard Allen, because it's seems to indicate that somebody else committed the crime. So I don't know. I mean, like, we'll see how it plays out. It's like, let me ask you this, man.
Normally you can't. So at least in Indiana, normally you can't raise a Brady claim, and probably shouldn't raise a Brady claim until post-conviction. And I will tell you why. And that is because you always want to back up a Brady claim with an ineffective assistance of counsel claim, because the standard of materiality is the same for both, a reasonable probability of a different result. And if a court says on the Brady claim, no, they didn't suppress it, then, and it could have been found by due diligence, then you're into the ineffective assistance claim. And you don't want to raise an ineffective assistance claim in a direct appeal ever in Indiana, ever. Almost ever.
So in Illinois, they say if it's apparent on the record, we have to raise it.
Yeah,
you know, they
not
say one thing with one stroke of the hand and another with another. You know how it is.
well, but I don't think there's the record for the Brady claim here. The ineffective assistance in Indiana can always be left until post conviction, even if it's raisable. But you only get you have to choose. And a Brady claim on the face of the record, you know, I don't think it's entirely on the face of the record at this point.
Right, I guess not. I guess it takes you know, I just can't imagine any court would believe any prosecutor who says he surprised me and said it for the first. It's the first time I ever heard those words, because I guarantee if we were looking at the transcript, the questions being asked showed he was eliciting that answer. He knew it was coming.
Yeah,
but
could be. Absolutely, but again, you have to tie it into the Logan thing and the box cutters, and it's just not. I'm not saying it's not a colorable claim. If you look at these, you know, there's the newly discovered evidence, but if you look at the two claims, the point of the two claims up front, the chronic claim about the safekeeping hearing, the standard for reversal there is prejudice is presumed. There's no harmless error analysis at all. The second claim about the knowing use of false evidence, the standard for that for reversal is really low. Any reasonable possibility affected the verdict.
Yep.
And I think one of you said something about getting the transcript of the juror's interview, and the juror can't, legally what the jurors have to say is totally irrelevant.
I wasn't going to call my husband out like that, right on out, but right, they can't consider what the jurors thought process was during deliberation.
But that doesn't mean it's not good that it's out there.
Right, I agree.
Right, in terms of like the reality, in terms of one of the appellate judges catching wind of the fact that you can't unring bells. It may not have any legal consequence in terms of being able to, but
I would figure a way to squeeze it in there nonetheless. Be like, right. You know, obviously it would have made a difference, but if you had any doubt.
Well, I mean, the idea, so, you know, one idea about the chronic claim, and look, you want to give, if you're trying to get a conviction reversed, you want to give the court as many reasons as possible to do it. And
them dirty pooling all over the place.
Well, and it's not just the dirty pool. I mean, I think there's, you know, anything that makes Rick look more innocent, getting it up there is important. And the reason the chronic claim is important, you know, I think I might have talked about this before, but it was about a month ago. Your appellate court in Illinois reversed a conviction because the judge kept the guy's lawyer from talking to him overnight before he was going to get crossed in a criminal case. And you know, it was kind of a no mess, no fuss opinion. And they said, you know, basically, sorry, we are constrained to reverse because this is a critical stage and it's chronic and we're done here. And think about, you're the Indiana Court of Appeals. And I'm not saying the chronic case wins in an appeal. I'm not saying, I don't know what, you know, Mark Lehman and Stacey Uliana are going to raise. It's there for them to raise if they want to. But if they do raise it, think of how easy it is for the Court of Appeals to reverse on the chronic thing, blow out the trial, and you know, they can, Diener's gone. Lesenby's gone. They can put it on people who are no longer players, and they don't have to get into the muck and the mess of all the crazy facts of this case. Right. And they can say, so sorry, we are constrained to reverse.
Right. No, I see the logic there. I mean, you want to give them that easy out where they don't even have to talk about the facts of the case. You know, it's for sure. Oh, boy.
I mean, so that's kind of how it's like chess and checkers and.
Right.
And frankly, I mean, some of this I think is, I really don't want to talk publicly about it. Happy to talk to you all behind the scenes, but there's some of this that strategically sets things up for post-conviction.
Sure. Can imagine. All right, babe. Well, you want to thank some people, or what do you want to do here?
Yeah. Well, you did a great job. I know you worked your ass off on this, Michael, and I know that there were a lot of people behind the scenes that were assisting in that, and it's powerful, man. It's powerful.
Well,
I think
well, there's another creator this morning that was saying, "Wow, all they've got's a YouTube vid." Ha!
Were they not aware of the multiple exhibits, or I'm assuming that's a pro guilter.
Yeah.
There's just no. It's just sometimes I just can't. I can't get in the head of somebody else. It's just shocking to me. And I see some people even here commenting, like we're drinking the Kool-Aid or, whatever the case may be. And it's like, how can you say that in light of, even if you just look at Ron Logan, it's just crazy. It's so crazy.
Yeah, it's a crazy case. And I think, coming to the conclusion,
FBI's report somewhere in the record already. They did that, identified Ron as being bridge guy. Is that of record somewhere, or probably attached to the?
not that I know of.
Yeah.
I mean, when I say not that I know of, you have to ask Sloopy or somebody else. Can I take a minute to respond to something that somebody was saying over on Reddit?
Sure.
Yeah, somebody was saying how that it's like just unethical to crowdsource a court filing.
They don't know anything about how lawyers work. There's an entire defense bar that is crowdsourced of all defense attorneys. There's a prosecution bar. What do they have? They've got the I can't think of it.
And I will also say that the unmentionable, while the unmentionable podcast spends its time accusing people of being internet cranks, the internet cranks did actual, invaluable, important work. All of them.
Right. But I cut you off from. I want you to say more if you want to say more about how they're trying to say that's unethical. I just thought, by the way, do you guys know that there's like multiple, groups of lawyers that work in conjunction with one another as a normal course of business, including the prosecutor's office?
Well, and they were accusing me of being unethical before, pre-jury selection, and when I was, out there saying, students and I were gonna, we're available to do vetting of jurors, and somehow that's unethical, and then we were stalking them or tampering with a jury or something. It's like vetting jurors is a perfectly normal thing.
Perfectly normal, and the end has been found ineffective assistance when it's not done and something's discovered afterwards.
Yeah.
So,
I mean, it's akin to arguing with a kindergartner.
Yes.
I mean, that's what it's like. That's why I typically don't like. You spend an awful lot of time, Michael, watching people that you're too smart to be wasting your time watching. I never understand why you do that. Like, I mean, people say shit. Like, I see Contrarian Dan in here. He's calling this an appeal. It's like, you have no credibility with me when you don't understand the process. If you're going to make a comment in here, at least know what you're talking about in terms of, trying to slam it. Like, this isn't the appeal. If people are confused, this is not an appeal. This is a motion to correct error, which is a completely different instrument that's filed at the trial court level. So, you know, it's like, I don't know.
Well, the person who thought it was a YouTube video at first, I mean, I think he did get clued in later on. I only do that as that person jumped to conclusions first. But, you know, I listen to the other people because other people have other ideas. And I got to say, even listening to what I refer to as the lynch mob, they raise questions that I figure have to have an answer. And one of the things this particular guy who thought it was a YouTube video at first was saying is, well, how are they going to authenticate that? And all I can tell, the time on those. And, you know, that's a legitimate question. And my answer is, I think the defense attorneys have ways to do that.
Right. And the pings corroborate that timeline. His phone is pinging at the same time.
Well, you know, this other creator was saying, you know, how does the FBI ping corroborate the time on the timestamp of the video? And to which my answer is, well, you're saying the time is because it's like 15 minutes and it doesn't take 15 minutes to get down that drive. And my answer to that is, well, guess what? You're right. The timestamp might be off. He might have arrived home even later.
Right. Right.
And I don't know. I mean, I listen to the other things because, you know, people have different thoughts, and I've heard things that are very useful on the lynch mob's channels.
Yeah. No, for sure.
So, like, when you were drafting this thing, I'm always curious in terms of the process. How do you decide? Like, well, let me ask before I ask you, Michael. Ali, what did you feel was the most powerful out of what I consider to be like 4 kind of primary arguments?
I thought the middle 2.
Yeah, I mean, like, so.
I mean, I assumed the last one, the 4th one, that an expert would say that that's not a thing, you know. And I think legally speaking, claim 1 is, you know, for a court compelling, but just as far as like overall, like speaks to the man's potential innocence is 2, and the timing of the white van and Ron Logan's confession.
Well, and Ron Logan confessed, by the way, not after being in prison for 13 months,
Right.
being slapped in solitary. And I mean, that gives that a whole different view. Look, the chronic claim, it's there, and the facts had to get in. And one value of that is that, you know, along with Rick Allen's innocence, there's his mistreatment. I mean, look, I mean, appellate judges are people. You know, if you can give them a view of a case saying, like, this should never have happened.
Right. From the jump.
This is ridiculous. I mean, anything that shows the total bollocks that this case is, you know, it might get somebody's attention, and it might not.
It's hard to know. It's hard to know what they'll do. You know, it's like it just is in terms of the appellate court. You know, I mean, we know what Gull's going to do, but you know,
well, you say that, and I'm not sure. I mean, I think there's at least a small chance the hearing will get set.
Really?
A small chance. I mean, who knows? I mean,
Hey, man.
I mean,
I appreciate your optimism.
She may be angry.
I have a deep feeling that she very much believes that Rick Allen's the culprit. You know what I
Well,
mean?
but does she after but does she after the van and the Logan stuff? I mean, really?
I don't know. I mean,
I don't either.
it's hard to imagine that she would, but
Or
you know,
it's
I
hard to
mean, at
imagine
this
she wouldn't
point,
at least have a doubt.
I mean, the
I-
Ron Logan, like you destroyed the timeline that the state won the trial based on. You destroyed it. I don't see a workaround for them. I mean, they knowingly put on false evidence. They knew everything. Like again, and I just want to restate for people out in the audience that may not have an understanding of where this information came from. This information was provided to the defense by the prosecutors, which was presented to them by law enforcement. So like this is not stuff that the defense just cooked up in a lab. This is all things that were located within the discovery itself, which means either one of two things. Either McClellan was not aware of it, or he was aware of it and just pretended like it didn't exist. Either way, it's a massive problem.
Well, that's the thing about a NAPU claim. No, there's the knowing use of false evidence. It's not just the prosecutors. It includes
Police.
the police. In fact, somebody, and I won't say who, wanted to change my wording of the state to the prosecution, and I said no, because it's the state, it's everybody, it's not the prosecution.
Right. No doubt. Well, I guess that the skullduggery hopefully is gonna shine a light on that skullduggery. All right.
Well, that's it. Look, I mean, the thing that, so I'm a member of the I'm a board member of the Indiana Public Defender Council, and I'm not speaking as a board member here, but, and I'm kind of a self-appointed public defender in habeas cases. I mean, I'm not really a public defender. I mean, I just like take these habeas cases and try and go win them. And that's the one place that there really isn't very much public defense. But my concern is that especially in small counties like Carroll County, this kind of stuff happens all the time. You know, Sheriff Lesenby sent Rick Allen off to White County, and you know that it may have been for his safety, and I'm not saying he wasn't well intentioned, right? He may have really been afraid that somebody was going to do something to Rick in the Carroll County jail, but that wasn't the way to do it. He needed a safekeeping order under the statute to do that, and you know, and then sending him off to the DOC. I mean, the judge helping out the sheriff make the safekeeping request with no lawyers involved. I don't even know if Nick McClellan knew the safekeeping order was coming. I mean, and there may be more skullduggery here than we even know about, because you all may recall that I think it was the 28th, there were reports, and I think they were inaccurate, but there were reports that Rick had already been transferred to a state facility. I mean, news reports. Sources say, where were they getting that? Was the fix already in, and who was doing it for the safekeeping thing?
Yeah. Raised a lot of questions. I gotta leave you guys, babe.
Why?
I gotta deal with Scarlett. Her
Oh,
sickness.
all right. I love you.
Love you.
Yeah, I have to say, man, like the Logan shit just blew my mind. You know, it's
Well,
it's
and he
just
did know, by the way, Anna Williams worked in a bar, and I can give you. Do you remember the Snapchat picture of Abby on the bridge?
yes,
And you remember there's nobody behind her.
correct.
So the way this happens is not bridge guy coming from the north side of the bridge. It's Ron Logan passes them on the bridge, recognizes Abby, and then turns around.
Yeah, I have to say, when I was, and I said it during my lives during the trial, the first time that I saw the enhanced video, to me, it sounded like Libby was talking to somebody. Like it didn't sound like she was narrating to me. And obviously people, and hopefully at some point we'll be able to watch that and they can come to their own conclusions. But it just like she was like saying things that didn't sound as if she was narrating. It sounded as if she was having some kind of like conversation with somebody because she was like whispering. She clearly wasn't talking to Abby because Abby was still however many feet away. Like she was kind of whispering, like which is strange. Like why out on that bridge, out on those trails, would anyone feel the need to whisper? You know what I'm saying? Like when you hear it, have you had an opportunity to look at them?
I have had access to discovery necessary for this filing. That does not include the original video or the enhanced video or anything. I'm an outside. Look, I'm basically an interloper.
Yeah, yeah. You're a good one though, man. You're the kind of guy we need interloping, you know? You're the kind of guy that we need interloping. So, well, I appreciate you, man. I appreciate the work you do. You know that, obviously. Um, and I think that you did really good work here along with everybody else because the amount of digging that had to take place to make this happen, I think is pretty legendary, to be honest with you. I was,
The most work was the scut work, and that was putting together all the exhibits. That's what I did.
yeah, yeah,
I think there's 16 of them.
yeah. There's a lot of them. There's a lot of them.
I think there's 16, and adding the certificates of service, getting the labels on them, writing the affidavits for people and getting them signed and getting them back and sticking them into PDF. I mean, it, it, it,
Yeah.
that
Well, no matter which way this goes down with Gull, you've done important work and you made powerful arguments. So, I mean, from this side of the bar, that's all we can do, and you just have to hope
yeah.
that somebody out there that has a robe on gives a shit,
Yeah, I think there's some talk about, even while the appeal's going, getting the post-conviction investigation going.
Yeah. Yeah. I mean, like I'm sitting here at the Ron Logan shit, man. Like what is the deal with this Ricky Davis? Like what was
So it's Reese Davis and somebody, this guy who said it was a YouTube vid, said, oh, he's a convicted murderer. Actually, no, he's in for 50 years for dealing meth. He's not a convicted murderer. I don't know about Haas. Haas is the other Logan guy. And there's another thing about Logan that's pretty convincing that sort of plays into all this, about why he would be confessing, but I don't think I can. I don't think I can talk about that yet. But Reese Davis, yeah, so he's in for meth. He's in Newcastle. He's got and he's actually a guy I did some work for way back when.
I mean,
So
like, because look, I mean, always the rub with these guys that are in, and when they're snitching, is that it's obviously the counter argument that they're doing it to get favors,
well,
either time
maybe
shaved
doing
off.
it to get. Maybe look. I don't care whether he's doing it to get favors. I mean, how could he make this stuff up?
Right. That's the thing. That's the main thing. Like, did he have any kind of uh relationship or knowledge of Ron Logan prior to being in a facility with them? Like it's a shit that he could only have learned from Ron Logan.
Reese was from Huntington, not that close, to Delphi. So yeah, and different ages, and I don't think there's any connection between them. I think it's what it says in I don't remember if it's a tip or where I saw it. They were in the same pod at Newcastle. Yeah, I don't see any. I mean, where do you make up the details of knowing one of the girls and grabbed one, killed the other? I mean, yeah, I suppose you can sit there and make up something, but doesn't sound made up to me. And I have not seen what the defense has on Haas, the other guy to whom Logan confessed. And it would be interesting to put that together. But it was the box cutter connection that made the confession to Reese Davis so important.
Just huge. It's huge. It's huge.
Well, thank you for your work and
Yeah, always, man.
contributing to rationality.
Yeah, we're always on the side of due process and the Constitution over here. That's kind of an important thing to me. Matters.
Well, and I think, for me, this is one of those cases where, yeah, due process and the Constitution can certainly protect the guilty too. But this case for me is an absolute illustration of how the Constitution and due process should have at least protected somebody who's innocent.
Right. I'm with you,
And
man. All right, so we just we wait and see. We see. I mean, I imagine the first thing that we'll hear is whether or not. I mean, she's going to rule on it. I imagine in short order, we'll know if she's going to grant the motion for a hearing. I would imagine that, like, if she's gonna if she's gonna just deny him offhand, then I imagine that'll be quick. Hopefully, she sits with it. Hopefully, she actually reads it. That would be nice.
If I were the judge, I'd ask for a response.
Yeah, me too. I mean, just out of pure interest, like, wouldn't. But I don't know. I thought that when it became clear that Nick had been hiding the ball on certain things, and and Allie and I were over here sitting and screaming like, well, I'm assuming she's going to give the same admonishment to the state that she did to Brad and Andy, and that never happened. She's just impossible to predict, but as a jurist, she's got a job, and I don't know.
Well, I'm just saying, this is the kind of thing where I'd want a response from the state before denying it. And by the way, if you're pro prosecution on this, remember I point out that if there's no hearing, the Court of Appeals has to take all the affidavits and the evidence is true. And so it's actually, if the prosecution has something to counter this stuff with, and who knows, maybe it does. We'll find out if there's a hearing.
Yeah.
It might be the pro prosecution move to set a hearing.
Yeah. I mean, but whatever they had to counter it, wouldn't it have had to have been in the discovery?
I don't know, and I wanted to say something about that because, and I haven't watched the entire interview. I've seen the clip, and I need to get the transcript. But I think Nick McClellan said something about the Google search and by Cecil, and what he said was, yeah, we had that in the report, and knew about it, but we just didn't think it made any sense. And so they weren't, I mean, so they knew about it, and so they didn't think the headphones being plugged in made any sense. So that's why they weren't prepared to counter. So he knew about it. It's not like they were actually, I think he was claiming they were actually surprised by the testimony. Well, they might have been surprised that Eldritch said the headphones were plugged in, but at least in that interview, he seemed to be saying, we knew about the data showing the headphones being plugged in and unplugged, but we just thought it didn't fit, so we didn't think it was coming.
Wow. That sounds like some ex post facto bullshit to me. I mean, like Cecil testified that he knew the language there, but he had no idea what it meant.
Well, I can only, and look, with facts in this case, there are people who are all over everything 24 hours a day. If somebody wants to correct me about what McClellan said, I'm here for it.
Yeah. Yeah.
But that was what I understood. But I think he also said, if I'm not mistaken, I think he also said that, yeah, the Google search was reliable.
It was like from an Apple support group. It's like it was ridiculous. Like as soon as I walked out of the courtroom, I Googled the same thing and I found the exact thing that he searched. Like he wasn't honest about what he pulled it from because I saw it. Everybody, like I saw exactly what he said was like from a random person. You know, when you get into like the Apple support group things, they have group chat things. And so it was like literally from there. It was crazy that was allowed in. It's one of those things where and that completely undermined that piece of evidence, which was incredibly powerful.
Oh, Allie was saying something that and either she or I misread Eldridge's affidavit, and I can go back and look at it, but she was concerned that water could cause, according to Eldridge's affidavit, could cause the thing to spontaneously reboot. And my understanding of Eldridge's affidavit was, and you can pull it up and fact check me, but I recall that she was saying that if it's water damaged, it can cause the phone to spontaneously reboot when you're doing a Cellbrite extraction. It's not that
Right.
it just.
That's the way I read it too, because it's this paragraph 18. It says iPhones that have recent water damage are known to reboot spontaneously, and it's comma, requiring multiple attempts to complete the extraction with a forensic tool. So the way it was written is a little clunky. It probably should have said while while attempting to complete extractions with a forensic tool, that it's known that iPhones that have recent water damage are known to reboot spontaneously during the extraction attempts. You know what I'm saying? Like it reads the way that you're seeing it. It's just I could see how it could be misconstrued.
Yeah, no, I now that you read it and with the comment and everything, and
Yeah.
I'm, yeah,
Yeah.
I just, yeah, it's, yeah, I still, fundamentally go back to like Rick Allen, 5'4", CVS manager, no criminal history, 10 years in the National Guard. like just goes out on a warmish February afternoon and slaughters two girls with a knife, and he happens to have a box cutter and a gun with him. I
Yeah.
mean, are you serious?
Married 34 years, kid raised, put through college. Yeah, I'm with you, man. All right. I'm gonna say thanks to some people.
Yep.
I appreciate you very, very much. I appreciate everything you do always. You know that. Enjoy today. I imagine that you'll have some fun digging around online. It should be an interesting day for you.
I
See
got
the-
I got to go do all the stuff I should have been doing last month.
Yeah, sure. Sure. All right, man. You're the best.
Thanks.
All right. I'll talk to
You
you
are
soon.
too. Bye.
Bye. All right. So if you guys don't know, that was Michael Ausbrook, Indiana attorney, habeas champion, habeas corpus champion, writs of habeas, files them, he wins them, and he is the author of what we have been reading today. He did a massive amount of work along with a lot of other people, which I don't know what the situation is with giving them credit publicly, but I know who you are, and you guys did amazing work. All of you. All right, so let me give you some thanks. Oh, and before we bounce, before I start losing people during the thank yous, busy day today over at Defense Diaries at 5:00. I have Lauren Bright Pacheco on for our weekly Q&A on the Murder on Songbird Road podcast, which is episode 3 just dropped. We're very proud of that work. We, we're looking into a case that we think might be a wrongful conviction. It's a mother of 4, brutal, sad, awful case. Really, really interesting though. If you have not checked that podcast out, I highly recommend it. Obviously, I'm in it, so there is some self-promotion there. But Lauren's going to be joining me. If you guys have any questions, I have a post in community under the community tab. If you guys have any questions there, you want to type them out ahead of time, I can check them out, because it's hard for me to go through the chat when we're rolling and I'm trying to engage in conversation. So that's a great place to do that. And then tonight, shortly thereafter, I'm probably only going to go 45, 50 minutes with Lauren, because 10 minutes later at 6 p.m. Central, 7 p.m. Eastern, part 2 of our interview with Brad Rosie. A lot's happened since part 1. So there's a lot of different stuff I can ask him. So it's going to be interesting. And I think it'll be well worth your time. So make sure you're joining us there. Make sure you hit that notification. It'll let you know when we're going live. And please, y'all, please like, share, subscribe, get the show out there. We just broke 37,000. We're really proud of that. The thing I'm most proud about is the community that we've built. We think you guys are the bee's knees. You're amazing. We love you guys so much. And we're going to keep growing. We're only 13 months into this thing, and I'm pretty proud of the number that we're at. But you guys can help us in ways that you can do for free. Just liking, sharing, subscribing. If you really love us, think about becoming a member. That helps us keep our lights on. And we really, really appreciate that, obviously. So thank you guys so much for helping us reach 37. Can't wait to hit 40 and then 50 and then just keep growing. It's fun. I have a lot of fun doing this with you guys, and I hope that you enjoy it. I think we bring some value to the space. So without further ado, let me go through, just give you some thank yous out. Rose Adams, member for 6 months. LFG. Indeed. We did the damn thing. Thank you so much for being a member for all that time. Angels, not devil favorite. Gift and 1DD podcast membership. Thank you, Angels. Appreciate you. Kaylee, I think we answered most of these. I have seen the interview with Ron Logan's ex-girlfriend. She was 100% sure that he was Bridge Guy and the voice. And she said that he did it without a doubt in her mind. Problem is, that's worth not much in terms of evidentiary value. But yes, I've seen it, and thank you for the generosity. Joseph Kane gifting 5 DD memberships. Thank you very, very much, Joseph. We appreciate you. Angels back again. Great coverage, Bob and Allie. Thank you, Angels. Thank you, thank you, thank you so much. Oh, and thank you to my mods. Thank you, thank you, thank you. I too often forget to thank you guys because we love you. We cherish you. We could not do this without you. I hope that all of you know that. I hope all of you feel that. Don't ever take it by me just forgetting it, that it's not always forefront in my mind. I always jump in our server and thank you, but I like to give you public acknowledgement, especially on lives like this, especially when I'm not really yelling at you, but just reminding you strongly, let people with opposing opinions stay as long as everybody's being cool. And it goes for both sides of this. As long as you're being civil, go at it. Have at it. Allie and I are lawyers. We debate for a living. We love it. We love it. We love it so much. So thank you, mods. You guys are amazing. Speaking of which, Jen, gifting 20 DD memberships. Thank you so much. I'm sure all the benefactors of that were very, very, very thankful and happy as well. So thank you so much you're an always giver, Jen, and you're a wonderful mod and human being. So thank you so much for your generosity. Jennifer Fox, 6,300. Thank you, Jen, for the membership. See, there's proof. I'm on my phone, so it doesn't let me get my own. Thank you, thank you, thank you. See, got the love right back there. Thank you for your generosity, Jennifer. Appreciate it. Jolene coming in hot with 20. Thank you for doing this live today. I'd much rather listen to you read it than read it on my own. Thank you. Thank you. Love you back, Jolene. Appreciate your generosity always. Kindness Cake, 5 pounds. Thank you, Bob and Allie, for reading and deciphering for us. Appreciate you. Thank you so much, Kindness Cake. We really do. Dan, my man, weak appeal. It's not an appeal, Dan. Laugh aloud. It's going to get bounced. Not an appeal. Come on, man. Do January, Millican. January, family hug. Welcome. January. Appreciate you. Una, member for 6 months. Thank you guys for all you do. Love from South Africa. Love it. Love it. Thank you so much for hanging with us. I know it's probably a perfect time for you. That was a nice early live. You got to hang with us probably for a change. So thank you so much for being a member for so long. We really appreciate that. Lead with Love, gifting 20 DD podcast memberships. Thank you so much, Lead with Love. We really, really appreciate that so much. Such generosity. You guys are amazing. I love it. Truth and transparency. You know I love you, girl. What's up? The lawyers throwing their D's and T's on the table. Indeed they are. Kenny Powers, also known as Dan the Contrarian. Contrarian Dan. I am still confused why the FBI wasn't allowed. You mean why they were booted? It's a good question. You'll have to ask Doug Carter. Maybe pose that question when one of the pro conviction creators get him on, which they probably will. Ask him, why'd you boot the feds? Lynette, $3 holla. Appreciate you, Lynette. Always. Lead with Love comes back with another 10 DD memberships. Thank you so much, Leads. You're extremely generous today. You're amazing. Oh, man. New member. We love it. Aw. My passenger 33 or me passenger. I'm going to go with my. It's probably me. Probably butchering it. Thank you so much for becoming a member. Welcome to the family. Shannon L. Gifted 1 DD membership. Thank you. Thank you, Shannon. Erica M. Yep, we agree. Thank you for your generosity. Mark Cohen debate. Sure, I'll debate him. I'll debate anybody. Am I not clear on that? I'd like anyone. I don't care. You got to ask your buddies. You got to ask the cops, see if they filed a complaint. Andy's there for it. I mean, he was pretty clear about that. You know, bring it to the table. See what the people that matter think. Thank you, though, Dan. Appreciate you. Angie Sherman, member for 2 months. Thanks for all your hard work, Bob and Allie. Thank you for hanging with us all the time. We really appreciate it. I love cranky Bob and Allie. Always. Thanks, Christina. I wasn't really that cranky today. I've been fighting this like weird phlegm thing that like irritates me. That is really a bigger source of my irritation than anything else. It's like I'm constantly having to clear my throat and it just won't go away. Super annoying. So, but thank you so much for your generosity. And I love Allie always too. Chastity, $10 holla. Appreciate you so much. Thank you, thank you, thank you. Asphalt Sally, new member. Aw, family hug. Appreciate you, Asphalt. Thanks for becoming a member. Obstruction of justice, $10. You tell him, Tammy. You tell him. Wilco girl, it's almost as if you're another Chicagoan. Aw, family hug. Welcome, Wilco. And if you're a Chicagoan, howdy, neighbor. Jojo, $10 holla. Thank you so much for all you do. Thank you for your generosity, Jojo. Appreciate it. April Nunya, $5 holla. Appreciate you. Appreciate you so much. Jen coming back with another 1010. Love DD. Love you back, Jen. Dr. Vonda coming in with 5 DD memberships. Thank you so much. Like, you're just amazing. We adore you so much. Bring your hubby back on. It was fun that time when he was I think he was in the chat. We enjoyed that. We enjoyed seeing the other half of Dr. Vonda K. We appreciate you so much, Dr. Vonda, always. Mudbug, $20. Keep digging always. You know, that's never gonna stop. Never gonna stop. Thank you so much, Mudbug. Shauna King, I sent in I posted these. I was hoping Michael took a look at them. I sent in video audio regarding the knowing of the white van as early as 5/21. And the statement given was, quote, "This is not leaked evidence. This is a rumor to deter the focus," end quote. Proof. We're done with corruption. Hear, hear. Thank you, Shauna. And thank you for being active out there. Thank you for not sitting idly by, for taking action. It means a lot. Not just in this case, but in general. Like, everybody that actually does things is always appreciated. Shauna comes back to add to that. The statement was given back in 6/21 after the leak. The corruption is real here beyond this case, but the same people and above. Thank you both. It's given us the courage to fight. Thank you so much for that. We appreciate that. And we appreciate your support. And we appreciate you becoming a member. Welcome to the family. Amanda the $5 super sticker. Thank you so much for your constant support. Appreciate you. Heather, thank you. Bob, Allie, and Michael. Yes, yes, yes. Thank you, Heather. We really appreciate that. And Hoosier girl. Oh my God, Hoosier. I did not forget that I owe you a Bob Senior puppet. That is coming. I promise you. I know I owe it to you, and it's definitely coming. When it's going to hit, you'll just have to tune in. It'll be a surprise. But I'll make sure that you're in chat when I do it. So, all right, you guys are amazing. Remember, 5 p.m., Lauren and I for 45 minutes, maybe 50 before, and that's on our Murder on Songbird Road Q&A. If you have any questions, if you haven't listened to that podcast, please do it. If you haven't listened to this podcast, go listen to it. You're going to love it. I promise. It's like the docket, you're getting a lot of the same coverage you get here, but as far as the Gacy and the Garcia, you're not getting that here. Go check it out. Go check it out. I promise you're going to dig it. I promise. Promise. And always 5-star reviews on that. All you have to do is hit that QR code. It'll bring you right there. We love you. All right, you guys. You are the best. Remember, like, share, subscribe on your way out. If you really love us, think about becoming a member. Allie, you stay right there so you can you can yell. And remember, y'all, without y'all, I'm just an old man.
Talking about a lot of cases.
Love ya.
Hudson.